Okay, GBA, we are live. We are recording. Phone lines are open. Go for it.
Thank you, Matt, and welcome to the Town of East Hampton's Zoning Board of Appeals for October 18th, 2022. We have two canceled hearings this morning. One is Montauk Sunset Cottages at 31 Eastlake Drive, care of Britton Bistrian, Suffolk Tax Map number 300-20-2-13.1 and 13.2. And then we have a recent a last-minute cancellation for Maurice Ayudicone at 184 Soundview Drive, Montauk, 300, tax map number 300-3-1-1.2 and 1.4. So with that, we'll go to our first scheduled public hearing. And I'll read that into the record. The applicant is Peter Ferrandino at 73 Surfside Avenue in Montauk, Suffolk tax map number 300-51-2-10. Again, the applicant is Peter Ferrandino. The size and location is 11,092 square feet at 73 Surfside Drive in Surfside Estates, Block 360, Lot 18, map number 6090 in Montauk. The description is an appeal of the building inspector's issuance of building permits 59-459 and 7144. The relief sought is an appeal of the building inspector's decision to issue certain permits pursuant to 255-830A1 of the East Hampton Town Code. The appellant seeks to challenge the building inspector's issuance of a building permit 69459 dated 5/29/2020 and amended under building permits 70144 dated 7/25/2020 and further renewed on 3/7/2022. The applicant contests that the issuance of the permits were deficient in regards to the East Hampton Town Code 255-142A, 255-130B, 255-420, 255-1172A and B, and 255-10A. The zoning district is B, Residence Zone X flood zone, and the secret class is type 2. And council, do we have a proper affidavit of service and posting?
Yes, pursuant to the Town of East Hampton Code, we have an affidavit of service that is dated October 6th, 2022. No posting was necessary on this application as it's an appeal to the building department's decision, and all parties were noticed.
Thank you. Do we have the applicant here this evening? Hi, Jameson.
Yes.
How are you?
Good. How are you? Good evening, Chair, members of the board. It's good to see you all. My name is Jameson McWilliams from Crouch McWilliams Law Group at 10 Pantago Road, East Hampton. I represent the appellant in the subject appeal, so we are the applicant, but it's an appeal. So the appellant, my client, is Peter Ferrandino. He is the owner and resident of 20 Hopkins Avenue in Montauk. He is the neighbor to the north. The backyards touch his yard and the subject premises. So as you mentioned, the subject parcel is 72 Surfside Avenue, Montauk. B zoning, it's approximately a quarter acre. The property is improved with a single family house that was recently constructed. The new house is, I would say, partially situated in the footprint of the pre-existing non-conforming one-story house. It was constructed prior to zoning, and it was non-conforming as to required dimensional setbacks and pyramid law. There is a CO. The CO for the residence before zoning was for a one-story frame, one building permit family residence having one kitchen, 3 bedrooms. You all have that in the property card. So I submitted this very short letter that kind of takes, I'm going to take you through the overarching, what's going on here. And then there's some nuances in terms of various surveys submitted by the property owner to the town over time that demonstrate slightly different values and numbers. And then hopefully we can go through some photos. So this application is for an appeal of the building inspector's determination, and that was for the issuance of the building permits. The building permits were issued in error because the proposed work required approvals from this board, the Zoning Board of Appeals, prior to the issuance of those permits. The height of the structure proposed exceeds the allowable height under the code. So the original building permit applications contained a SASCA survey, last revised April 23rd, 2020. And there's a copy in the file, and then it's in my photo packet. On that survey, there's a notation that the top of the railing elevation is noted at 82.4 feet. And on the same survey, there's a spot elevation on the corner where this structure was proposed, which now exists, at 55 feet. So that the proposed height exceeds the allowable limit under the town code and would require a variance prior to the issuance of those permits for that structure. I was able to get a topographic map from the town's GIS office with 1 foot contours, because what was difficult to ascertain sort of was the elevations and how they may have changed over time through the surveys that the property owner submitted themselves, and then a survey that has spot elevations. So the topographic map is also included in the file. I would say it's upon information and belief that the data is from around 2004. That's what they indicated from the town office. Because the determination of height as defined in the town code, it's very specific at the height of any point of a building or structure shall be the vertical distance from such point to the natural ground elevation directly beneath the point whose height is being measured. It goes on. The natural ground elevation beneath the second story addition is either the spot elevation on their survey, or if you look at the earlier topographic information that the town maintains, that would be 51 feet. So to have the house proposed at the 82.4, then they're well beyond the allowable height.
What are you saying is the existing height? Or
I do not know the existing height. The height that the permits were issued for is 82.4 feet. That's the height indicated on the.
what does that height represent? The height of the building, or?
From the elevation, that's the highest elevation. So all
right, so an existing grade at that point
is either 55, according to their survey, which shows apparently the topo lines from 2019, or the earlier topographic map, which would say that it's 51.
Is that a surveyed elevation, 55 feet? Do you know if that's a surveyed elevation?
It's not my survey, but yes, the survey's stamped.
So
Yes.
it's a surveyed
Yes, sir.
elevation.
It's that the value of the 55 spot elevation and the value of the height is both on their survey that they submitted. So that would be 31.4 feet.
there's a pyramid diagram on Wasaska survey saying the first floor elevation is 59 point.
Right, the finished floor, right? So, but if you look at the spot elevation in the corner there,
He's saying it's property line is 56.7, right?
do you want me to keep going, or because I can answer this now, or so if you go, Brian, if you don't mind. Once you see the photos of the house, you'll see that
But photos won't tell us
The measurement.
what it is.
if you see the photos of the house and then look at the surveys, it will be you can contextualize.
Yeah, but that's supposition, wouldn't that be? I'm trying to figure out,
Okay, I'll.
you have to go by surveys, I would think.
Okay, so the first survey that they submitted is the survey dated March 30th, 2017, and last revised April 23rd, 2020.
Brian, are these the photos that submitted by the applicant?
That's correct. I'm sorry, they're not up on the other screen. That's why I kind of had to wheel around and make sure that
Okay, yeah.
they're up there.
Okay.
But if you see the front of the house and the driveway, that's the first photograph in the applicant's submission.
Do you mind just going ahead? They're asking a specific question of the survey.
Sure.
Sorry, I mean, unless
Yeah.
it would be
Yeah.
page. Maybe page 10 of that, or it's, I mean, it's there, it's in your file too. So I don't know if you guys have the survey
We have the survey.
that was in the memo from the planner. Can you go to the next one? And maybe the one after that. Okay, so this is the survey that they submitted for their building permit application. So in the report here, there's a spot elevation that the surveyor placed on that says 55 feet.
I'm looking at the pyramid diagrams and all of them say 56 point something. One says 57. I think that was the existing. Right, go ahead. I'm sorry.
So if at this point, this is the front of the house, have a spot elevation of 55 feet. And they're showing the top of railing at 82.4 feet. And the town code requires that you determine the height measured from the natural grade directly below the highest point of the structure. Then the finished floor elevation in my reading of the town code is not necessarily the natural grade, the natural ground elevation.
That was correct.
So this document, although they presented this and got their building permits, if you put those two numbers together, it exceeds the allowable height under the code.
The difference there is,
If a proposed home is 82.4 feet tall and the natural ground elevation per the surveyor is 55 feet.
you're saying that's 27.4 feet above natural grade.
And the allowable height for a flat roof structure is 25 feet.
Right.
And then additionally, the question in my mind is, where do you get there are other documents that show varying topographical measurements. So the natural ground elevation at this particular location has been manipulated over time. And you see that again next. The applicant submitted a subsequent survey, which would be the next one. All right, Brian.
That's okay.
So this one, the only change regarding their plan, I guess, is they changed the configuration of the pool. Then they submitted another survey. And this one has spot elevations, updated spot elevations. So this is the Saskis survey. Same date, last revised May 26, 2022. Interestingly, a lot of the other information is removed, but it does have the, locate house with elevations. On this one, you can see that the spot elevations in particular in the front yard are now at 53, varying around, 53.1 in the front, 53.7 in the middle, 54.8 now at that corner. And in their prior survey, the topographical lines are drastically different. So when we got involved, when my client noticed that they were breaking ground and the work began and there was fill deposited onto the site, that was in April. They first hired someone else to just foil the documents, took a very long time. They started to get nervous because there was a lot of work going on. The fill had been deposited and then over time has been now flattened out. In our mind, even though the original permit application does not include a pool. In fact, the property card says specifically no pool and spa at this time. They had a survey that indicated a pool there. So likely, if you will go back to the photo, hopefully of the before photo of how the topography of this lot originally, or the before, I don't even know, obviously I don't know the natural state, but there was a big slope up to the house. So if you wanted to locate a pool here, you would have to flatten this out in some way. Additionally, the original pre-existing structure was this one-story house set all the way back at the closest point. One survey shows it was 3.1 feet from the back property line. That's the little like window well. Then it's think about 5 feet. It's a little bit on an angle, but it was all the way couched in the back. And then Brian, I'm sorry, can you go to the first photo again?
There's no reason to apologize. I'll go wherever you want. First photo in the package?
Yes. So this is a Google Earth photo from 2013. And this is what, in my mind visually is the sort of before. So at least you can get a sense. I know that this is not evidence or facts of anything, except that you get a visual of how the house used to be situated on the property and how the elevation came into play and how you could, the driveway was there and you would enter. This was the one-story house with the drive-in garage. Now, if you look at what the proposed new plans are and what is existing there now.
But that doesn't really come into play, right? There's a building permit that was issued based on a set of plans, what the existing house was. So there's a proposed plans that are submitted. That really why we're here tonight. I don't know if that comes into play and is as far as importance what the existing house was. If you look at Saska's survey, and you take his points where he's saying natural grade is on his survey, where did the 82 point
His survey, sir.
from the height of the building?
Yeah.
Yes.
Okay, so I'll look at that.
And then it does, and
So that's fine.
I,
He's saying natural grade is 56 point,
no, 55, there's a spot elevation on the corner,
but his
Yeah.
elevation diagram.
but that's the
I get
finished
that,
floor.
I get that. What's that?
I mean, the natural grade and the finished
Oh, it says
floor.
property line. But you're going by natural grade by the corner. I get it. Okay.
Yeah, the definition of height doesn't say at the property line. It says at the point directly below the highest point of the structure. And the reason I do think that this is relevant is only because this is a pre-existing non-conforming structure. So there's also the section in the code that says that you cannot increase the non-conformity of a non-conforming structure. In this case, the non-conformity is the proximity to the back property line, the side property lines, and the fact that it did not meet pyramid. Now they're proposing a second story. I will say that based on some photographs, it's possible that they are mindful of that pyramid. But again, the plans and the permit application and the survey, in my opinion, are deficient in that there is nothing that I can tell how high is the highest point and how far is that from the back property line? Does it meet pyramid? On that same first Saska survey, there are some inset pyramid analysis. And if you look at the proposed pyramid analysis, east view is looking at it from the front. Then we have the pyramid analysis east view showing the existing, and the pyramid analysis south view, which shows this existing, meaning not now, but when they filed. This pyramid analysis of the south view, which is showing the pyramid from that back property line, where at the closest point it's 3.1 feet, doesn't show the proposed second story. So based on this survey and the plans that were submitted, which I think are deficient also, they're missing a lot of the elements required under section 102-7, I think, of the code. They're not stamped, they're not sealed, but they're not stamped or signed. They don't show dimensions from the property lines. They don't show square footages and elevations of proposed heights or of all new proposed construction, which is in the code and on the permit application. It's like trying to piece together a puzzle to figure out how high they are and how far they are from the property line. So with all of this information, and trust me, I have been studying it at length, I think that the permits were issued in error because there's not enough here that says that it does meet code. The only things I'm seeing are that it doesn't meet code. It's too high and it would need a variance. Additionally, there's work still going on there that also needs an NRSP. There's a wetland across the street. So there's work that has been done within 100 feet and 150 feet.
What work is that?
All the fill that was brought in would need an NRSP. All the materials for the driveway. Some sort of walls are being constructed now that might not be within the setbacks. There are no plans for those. There's no application. There's no building permit.
Painting wall that's mentioned in the letter?
Yes, ma'am. So that's already, there's a partially constructed. So that was constructed as of Sunday. And the frustration has been on our part. It's seemingly there's been a lot that's been allowed under the permits that we think were issued already in error. And then there's just continuing work occurring outside of those permits and then beyond where they have submitted the letter, which in my opinion also says right in there that they acknowledge that they need it. This work requires an NRSP and that the application's forthcoming. And that was in June, the letter. And now they're doing some of the work, but I don't think that they've gotten their NRSP from you all.
How has the issue of the fill been addressed with the building department? Have you brought that? Has that been part of one of your letters, the additional fill?
Yes, sir.
I see it in here, but you go ahead. Tell me.
I originally filed a complaint with the ordinance department for the fill being deposited within a wetland jurisdiction. And the question of this height, it was going up quickly. And what we could see, it was hard to get the documents in, quickly enough, but it just looked too tall. And the fill being brought in, especially in the front where this was swooping, sloped.
Photo of that?
Jameson, on this photo here,
Yes,
so this is Surfside?
yes.
And where's the wetlands relative to it?
It would be, if you're standing in the road, it's behind you and over your right
It's on
shoulder.
the survey, right? So,
Yeah.
So this is what we consider the before photo.
Yeah.
Can you go to the next one, Brian? We can just go through these quickly. Oh no, and now they're like zoomed in and out. So initially also, this is what my client saw. This is actually a Google Earth photo, but this is what he was calling and saying. The house, this one-story little house close to his yard was up on stilts. This is what the application, the permits are for, was for the interior alterations and a first and second story addition. What ended up happening, which Ann said is actually, that's like sort of I'm not saying loophole in a negative way, but it's in the code. They were able to lift it, pull up the foundation, pour this new, larger foundation, and then that house disappeared. So this is the expansion of this pre-existing nonconformity in terms of how close it could be to the back property line, but this pre-existing nonconforming house does not exist. So the next photo, which may have come from Ann, this one. This shows how close it is, but also it shows like this is just brand new. This was when the second story hadn't gone up yet, but this is the new house on the old footprint.
So you're saying that this would be classified as a redevelopment, a total redevelopment. Is that what you're saying?
I would say so, yeah.
And they didn't get a demo permit?
No, they didn't get a demo permit. Even if you didn't need an NRSP, by the way, you do need a building permit to bring in that much fill also. It's more than 50% of the lot size. And by their own surveys, it shows that it's up to 6 feet, 5 or 6 feet of fill in the front yard there. I mean, they brought in a tremendous amount of fill. Can you go to the next one, Brian? So this again is like an earlier photo, and this was sort of the side that gave me the most pause in what was happening here is this, where you used to be able to pull up and under, and now there's this elevated foundation where they had to bring in the fill to even get to that point to elevate it to the foundation there, and then the house is going up from there. And the only thing that I can ascertain again from the plans, because you can't get any of the full heights with including the finished floors, including the required railing because they're proposing this roof deck, is where's the natural elevation? Like it's changing in front of our eyes. You know, the next one, Brian. So this is from the street side. This is showing really the difference in the fill from the front.
Where is the retaining wall gone?
It's back by the dumpster now. Not when this photo was taken, but there is one of a portion. I don't know, again, what the plans are for this entire retaining wall system.
I mean, this photo could be the storage of fill, temporary storage of fill for construction. However, I think the issue of whether or not they encroach on within jurisdiction of wetlands, that might be an issue.
Yeah, I
That doesn't mean
respectfully,
that
I
they're
don't.
regrading it to that level.
I don't think there's a question that that's within wetlands because it's a very small lot and you can see on the surveys how close to the corner of the new structure is 170 something feet. So, and the whole lot line is 190. So this is definitely within the NRSP jurisdiction, It is also possible it was presented at one point to Ann that this was temporary fill, that this had been what was excavated from the digging of this new larger foundation, and it's been flattened out, but it also had to be flattened out and backfilled to even house this whole entire addition that comes up and out from the front. And now, as we see from the latest survey that they submitted, which I have a copy of, I didn't see it in the planner's memo, so it's in here. Now they are proposing the pool again, which they're going to need the yard to be flattened anyway. So I obviously don't know for a fact if this has been here since April, if it's temporary and why it's still there, whether it's being removed, and then where they're siting the pool and at what elevation, that I don't know. But what they've done so far seems to be out of bounds of what they were approved for. You go to the next one, Brian. So this I only showed really to get a sense of the height of this in relation to the neighboring property and visually to see that there is being proposed this roof deck on top. The house next door is also pre-existing non-conforming in terms of the setback, but it's originally, I believe it's in its original state, it was always a second story here. But if you can sort of visualize again how the slope used to look, and it's very light here, but you can see there might be another photo that's better, but they did add then this like white stone as sort of this driveway material. Again, at some point is within at least 150 feet, if not closer to the wetland. You go to the next one, Brian. And this one I put in here too, because this was maybe invasive for these men that are working, but they're right there in the front and you can see, I don't know how tall they are, but you can see even, the difference between the natural or whatever the elevation is, the ground below them to even the, how many steps it is up to that finished first floor. And then you're measuring up from there. It's still just appearing as very tall in relation to whatever the natural ground elevation is there. Go to the next one, please. This was just to show the driveway. There's a better photo of the driveway to the right there on the bottom right. This is to show, again, that's the neighboring property. Again, to keep in mind that they're proposing this roof deck with the code compliant railing around the top, and also why it has been difficult even visually to understand if they have increased the nonconformity of the pyramid of that rear line because of how, the addition of the second floor is situated there. That's just a visual of how close it is to the back property line. Go to the next. And then this is bad, maybe we can zoom in, but if you look closely, it will be easier to see in your packet. That's where there's this additional construction that's going on. I mean, obviously you can see that the house is becoming more finished as the photos progress, but now there is this wall, retaining wall to the right there. Again, there's no permit for that. They're working outside of the permits.
But the retaining walls that you're referencing have not been shown up before on the any print that was submitted to the building department.
As far as I know,
No.
most recently I submitted a FOIL request for all the files and anything that had been submitted recently, and an updated copy of the building card on Friday.
So at some point in a future inspection of the site, it might turn up that there are some retaining walls that don't belong on the site and maybe fill that doesn't belong there. And that would all fall under the jurisdiction of both the enforcement and the building department. But you're here tonight in front of us saying that one of the things that we are looking at is that the original prints were approved by the building department to move ahead with construction. And you're saying that at the original proposal, it was proposed that the house would be 27.4 feet above natural grade. That the closest point to the highest point of the house, that's 55 at natural grade, and it's 82.4.
Yes, sir.
So some of these other areas we're talking about are of interest, but they're not necessarily something that we're going to be looking at right now. The building department will look at it.
Yes,
As
and
we
I
move
understand
forward.
that this is,
Right.
I've been trying to keep all of these lanes
Giving us the big
clear.
picture, but I'm saying what we're
Yes.
particularly going to focus on
Yes,
is whether or not if you're disputing the building department, the building inspector's decision, it's the question of the interpretation of the difference in height between 55 and 82.4. That's basically it. Am I right?
yes. And that and the survey, I think, is missing the pyramid analysis of the relevant property line. If you see it, if you see the GIS aerial that was in your memo, see a bird's eye view of this, that is clearly the subject line that is so incredibly close to the rear and what was non-conforming, and that's absent from the survey. There are also, put them in here, there were emails when I foiled the file earlier. They provided me these copies of these emails between the applicant and Anne, and it was in late 2019 and then in February 2020, excuse me. And she is asking for, I need the height from natural grade to the top of the railing. Max height for flat roof is 25 feet, including the railing. That's in the November 27, 2019. That's also in the packet. Keep in mind and beware that this work is tight on setback coverage and pyramid. I read that. I said, I agree, right? And you see the next email from February. And she says it again, I need the height from natural grade for a flat roof has to be no higher than 25 feet to the top of railings. Also, sorry, just noticed this, you have wetlands across from the property. Did you ever do a lot inspection? Then you see the plans, and then you see the permits, and there's nothing else in the file. And I still think that those questions are outstanding, and that the permits should not have been issued for that reason.
Who's Mike Brosnan?
The applicant on the building permit application and who the permits were issued to.
So you know,
Who's the builder?
I don't know.
You know that any application for a swimming pool would have to come back in front of the board if in fact it's within our jurisdiction. And that would include the fill and include the swimming pool. So that is a proposal, not anything we're considering at this point. You're just bringing it up because you think it's part of the future planning.
Well, so yes and no. So what I first got from the building card was the notation of this letter dated June 23rd, 2022, signed by Joel, who's here, I think about a different application. And so that was addressed to Anne, saying that, I mean, you guys can read it, but we understand that there may have been some property owners that have issues that this work is not properly permitted. We have the full intention to submit an application to the town of East Hampton when the design is complete. And it also, the first line says, we're in the process of preparing a natural resources special permit application for the change of grade to the property. So this is in June. That's a good start. Obviously, they were aware that property owners had issues with the work, probably me bothering the town and submitting things to the file. But that was in June, and then the work has just still continued. And it's outside the bounds of these permits. And this, in my opinion, directly affects these permits because of the grade change. It's not just the front yard and it's not just the pool, it's the grade change to boost that front yard so that this addition could even come out in the first place. And then it's not on the building card, but they did submit an NRSP application sheet for the pool. There's a survey associated with it. So I had that's a copy in the file too. So there's now this new survey, which is a variation of these, there was the Saskis surveys, 3 so far, pool, then the pool in the other orientation, then just the spot elevations. Now there's another one that shows the pool again in another orientation.
I want to keep this going. So is that pertinent to what we're doing tonight?
Yeah, well, he asked me about the pool
Okay.
application. So I don't want to speak on behalf of the applicant, and I don't work for the town. I believe that they submitted something. There's a survey in the file, in the planning department's file, and it's in my packet. That's the most recent survey submitted by the property owner about the subject premises. What's interesting only in that one is it has now their topo lines, and it is indicated that the topo lines are from data from 2019. So at least we have a snapshot of what the lines are in compared to the spot elevations that they submitted on the previous survey. So you can put those numbers together and see what fill they have brought in by their own documents.
Do you have any questions? No? Sorry.
No.
Anything else?
I hope not. Sorry, I know there's a lot here. It's not that difficult.
Thank you.
Thank you guys very
Well,
much.
you had, I'm just looking at your appeal. And want to make sure
Oh, we hit all the,
you had 5 things listed.
yeah, so the 255-142A is the expansion of the nonconformity. And I state this honestly, it's hard to determine that height and the pyramid. It's just not submitted. It's just not part of the record, in my opinion, and part of the file.
Didn't you raise something about GFA?
No, that's in Ann's, no, only in that one email where she says
Oh.
coverage might be an issue, but then this is that I think that the permits were issued in error because they would need the NRSP for the additional fill and or if the fill closest to the property, closest to the house is outside of NRSP jurisdiction, needs to be included in the building permit application because bringing that much fill requires a building permit. Then there was no demo permit, that the height is impermissibly high because it should be measured from the natural ground elevation. And I think that's it. But thank you for making sure I hit all of those. Thank you, guys.
So the question is, I think we have opposing counsel tonight? Do we go to the planning department first or do we go to, what do you think, counsel?
I would let opposing counsel probably speak. And
Floor plan?
planning permit, 'cause we're waiting on Ann to, she's gonna get here as well.
So we'll go to opposing. All right. Come on, Andy.
Good evening, Mr. Chairman, members of the board. I'm going to try to be as brief as possible. Rick is also here tonight with me, who also represents Seaview and Surfside, which are the owner of 73. So we're going to kind of bifurcate, but there's a reason I'm here and I want to tell you about it. There's also a third counsel, Roy Greenberg, who represented them on the purchase, et cetera. Dave Saskis is available. I can text him if you wanted him to call in. Basically, he's the one that submitted all these surveys and the prints and everything. And I thought if there was a question that came up, basically my feeling was that what I wanted him to testify is, but it's kind of also implicit, it's expressly stated on the map, he used actual field topography. So all the topography you see is measured in the field and certified by him. So when he puts his stamp on there, he's the licensed surveyor. And everything is in accordance with what you see on the surveys. But let me know if you think he's relevant. 3 things that I want to address just as right out of the gate. One is the top of the railing. These are glass railings. I think the zoning board is aware that glass railings, the building department allows you to exceed total height limitations based on the top of the glass railing. So the 83.9 or whatever is your required glass railing at the top of that structure, but it's not included in total height and it's allowed to be outside of the grid. So, that's that 83.9 number that keeps banning around. In actuality, the survey shows the roof height at 80, the top of the ridge at 80 foot on the flat roof, which complies with the 25. The retaining wall, which is entirely out of jurisdiction, is 4 feet or less. It doesn't require a building permit under our code. And the third thing is the letter or the pending NRSP. There is an NRSP pending that is in fact designed to be temporary storage of fill. We don't have a design that will say what we would like the finished elevation to be. If we don't proceed with the NRSP, we would have to restore it to the existing grade before, which is well documented in front of you. But that's what the NRSP is pending for, is the pool. We just don't have the final design to say, okay, this is how we want it to look. But I don't think you need the fill to build a pool. You can elevate the pool if you wanted to. I did want to make one comment for the record. I believe this appeal is time barred. It might even be time barred just based on the photos that she showed you. Said, oh, this is when my client started to have an issue on this property. I want to preserve this for our right to assert this. Should it be appealed?
Just refresh us the time bar. It's 60 days?
It's 60 days. And the question is, when does that apply from? It doesn't apply from the issuance of a building permit. You would have no idea that a building permit was issued to a property if you were the adjacent property owner. What it is constructive notice. I think Rick is going to discuss this a little bit more, but there was clearly active construction going on and constructive notice that there was issued a building permit, including a copy of the building permit itself, which is usually posted on site. We've had COVID, we had supply chain delays. There's all kinds of stuff that intervene in this crazy time frame. But I do know that second floor was framed in March. That's, I spoke to the contractor, said, yeah, that it was built in March. I think I have a picture showing it in March. This appeal was filed in June of this year. That's well outside of the time frame. It exceeds 60 days constructive notice standard if we use that as the absolute trigger. But clearly this owner was on notice that there was work going on long before that. So I think that's being very generous, but it still would be time barred. April 7th would be the date. If you were to say 60 days from April 7th, then April 7th, I'm sure those photos she showed you predate April 7th, the one that she said. I've never been on this side of the application, of an appeal. I will tell you from a landowner perspective, this is a pretty strange experience. We had no idea there was a filed appeal, and the actual legal notice never arrived at my client's address. I think it's to the post office or the actual property address. We checked it today. It isn't there. As the person most affected by, or the owner is the most affected by the appeal, it just seems a little crazy, the actual notice we get under the town code. The first one would be the 10-day notice that you get under the thing, and I'm not saying that makes it improper, but it is something we should look at and say, well, gee, shouldn't they have been notified of this before? We actually got notice by happenstance because Joel was checking the agendas for this meeting. So I think it was September 30th he noticed it. He told me on October 3rd or whatever and said, hey, by the way, there's an appeal on this property. You have to be there tonight. And we debated, well, geez, we haven't gotten any notice. We didn't know about this, but we're here tonight. We have nothing to hide. So this time barred thing, I don't think is a really great issue to discuss with you guys. It's a legal issue. We have nothing to hide. So I'm here to discuss the substance of this plan. And I think I can do that succinctly and tell you my story. I'm here for a really specific reason. Mr. Ferrandino bought the lot on which his house is built in 2006 from me, not my client, from me. I was the owner of that property. I sold them to Peter after getting a full set of permits for the house. I actually appeared in front of the town. I think I bought it in 2004. This is going to be my forever home. I did the permitting for it. I designed the house. This was my dream, is to be there. I lost the argument with my wife. I mean, it was 16 years ago. We didn't have kids. We didn't, it was a whole different world in my lifetime. I was living in East Hampton. I was very happy in East Hampton. All our friends were in East Hampton. Hindsight being a funny thing. I live in Montauk now. I have my kids in the school. But this was the right idea, but it was just terrible timing for me. So I'm going to file that one. The fact that I sold these lots at all under shoulda, coulda, woulda. But I am intimately familiar with this property. And as far as I know, the design, the Ferrandino house is more or less the permit that I got for this lot. I wanted to submit a copy of my permitting survey for this property. It confirms the grade elevations on this lot and actually shows the grade elevations on Surfside. How many? I'll give you 4. 1, 2, 3, 4, and I'll give one. Yeah, I have one. So here's one for the file on you, and here's 4 copies. This is my actual permanent survey for the Ferrandino.
The sticky point for me, Andrew, is this the disappearance of the existing house. Can you address that?
Well, the house can be reconstructed under our town code, provide a non-conforming structure can be reconstructed under our town code, which is more than a 50% replacement by cost, provided the degree of non-conformity is not increased. So lifting the house, putting the foundation, setting it back, and reconstructing it, truthfully, I don't even think it requires a building permit. You know, that might be a question for Ann, whether or not a building permit would be required to be submitted to reconstruct in place in kind. But that is not.
Definitely would need a building permit.
All right, and that's a question for Ann, but Rick and I, neither of us really knew the answer to that. But with that survey, you'll see, and I did highlight a couple of them, you'll see that it confirms grade elevations, 58 and 60 feet on the Surfside property. And this is an entirely different surveyor. This is Walsh Surveyor. In 2004, probably, he did the topography. It confirms more or less matches exactly what Saskis shows today. As a matter of fact, the one thing that's really clear to me, and was clear to me at the time, my property was at an elevation of approximately 60 feet. I intimately understood that when I designed this house, that if you changed my house to a flat roof foundation, that'd put my ridge elevation at about 53 feet, figure 3 feet out of grade, add it up, you're at 83 feet, maybe a little lower. Essentially, a 2-story house at 55 feet of elevation would have a ridge at 80 feet. There's frankly no way that I thought, or even anyone could reasonably expect, that a view shed on this property to remain after you built a house in front of it. I mean, I knew that at the time when I owned this lot and was developing it. I knew it wasn't going to, whatever was there was not going to survive a redevelopment of this lot. As I said, a roof deck, maybe you would have some expectation. Ferrandino could explore that in terms of putting it on, but I didn't design one. I know how awkward they are. It's like, hey, let's go to the roof deck. Everybody grab your drinks and you this and that. Oh, you have to go to the restaurant. Basically, it's one of those things that sounds great. In reality, my experience was they weren't being used. I didn't provide one there. I bought this lot solely for the location. I sold it solely for the location. I don't remember being asked about forever views on the property like you see on real estate listings. There never were any, forever views to sell on this property. In fact, just a cursory review of the existing houses along Surfside, even today, some of them remain exactly as they were in 2006, would show that a second story would impede the view from the Ferrandino property. I think this is Hope's drone photo right here that was shown to you. That's the second story here. This house has been there all along. I was there today. I'm guessing it's maybe 2 feet lower, but there's no way that the Ferrandino house wouldn't be blocked by even that lower roof elevation. And it was at a lower elevation. So, to say, oh, well, I always thought I was going to have this view. I don't see how it is frankly reasonable or even possible. In 2004, that house was owned by, the 73 Surfside was owned by DePasquale's, and that's Gene DePasquale, swim coach, also our town assessor. That was his parents. I actually inquired with Gene about trying to purchase it. Keep in mind, I had no money, but I was like, geez, it'd be really great to know. I would have probably mortgaged my children that hadn't been born or even a glint in their eye, because I wanted to have control over this looming issue that I would have said, hey, if we're going to locate here, we should really control this structure, because I knew it was important enough to see if it was even possible. At the time, Gene said, oh, my parents are there, they're living. Ultimately, I think it was sold 14 years later or whatever. That's a long wait game, basically. But if I had been offered the opportunity, I would have done anything that I could have to try to get my hands on this property for this exact reason. It was a foreseeable issue that the redevelopment, and it certainly wasn't lost at me at the time. 2-story house was something I wanted to avoid, and what lands us here. I would have no grounds to appeal in front of you guys. I understood it at the time when I sold the property, and my own independent survey confirms the elevations on the seaside along the property boundary. And they make my concern at the time identical what is driving this appeal tonight. Second point, The town's been really lucky to have Ann Glennon serve as our chief building inspector for the last several years. Frankly, I don't think anybody really knew what to expect when she was initially appointed. She served with honor, integrity, and brought an intellect to this position that I think has really benefited the town. Her diligence has greatly benefited the town. I know she's approaching her retirement, and we owe her our appreciation and thanks for assuming what is a very difficult position in the town during a very difficult time, even discounting COVID. I mean, this is a tough position. I will tell you that if the town had a central water cooler that we all went to, the discussion around it would not be over the last few years that the building department is really lax and permissive under Ann's watch. Quite the contrary. Ann's guidance has made everyone work a lot harder, spend more time demonstrating that our applications are in conformance with the town code requirements. I haven't always agreed with her, but it is usually because she is more restrictive and protective than how I would interpret the code. But never have I experienced her to be on the permissive side of the equation. Basically, Ann Glennon has done her job and done it well over the years, and the facts will confirm this. When I first heard about this appeal, I was never even worried. I have faith Ann Glennon did her homework and was correct. And with that, absent some questions of me, I wanted Rick to get up and actually address the facts because he was more involved with the facts. I was more
All
involved.
right, this is going on long, so let's try to be brief.
Well,
Get
you know
brief
what,
about this.
between Rick and
I
I,
wanna
if we
move
had a
this on.
contest for brevity, I think it'd be a draw,
Okay,
but I'm
Rick.
going to try and tell him. Be brief.
Be pointed, please. As you always are.
Let's
Surveys, 3 surveys, 3 more.
let's hope Andy loses.
Down, how you get to the second?
Give me one.
I'll mark it in.
Pass this down to her.
Are these different?
Are they different?
3 different surveys.
So you're giving us in order. Okay, these are two.
Do we have?
2019, 2021.
Oh, I see.
I'll pass this one down. Here's-
Oh, wait, I don't.
I gotta receive, I gotta do 3. There's one here.
There's one there.
I'll give one.
You have to sign each
These are all the
copy.
same, yeah.
Oh. Okay.
Here's one there.
No, but I don't want to take,
I think you gave
they
it to
sorted
the same
out.
thing.
Use here.
It's all dated
Terry, do you
differently,
have one
correct?
with the-
I
you
have
one
2
with the
October
pyramid?
1st, 2021. Oh, is this for Denise? Maybe that's for Denise. Okay. I don't have that.
Take the whole bunch and you can hand it back to Rick.
There's a lot of October 1st here. Oh, no.
There's a
He's
19,
got several.
he said there's a 19, a 20, and a 2021.
December 26, 2019.
And I guess, council, you need one for
I
the
have
file?
I gave her, actually, I only gave you one.
Yeah.
So there's a 2020 I don't have.
What's this one?
Well, 2021. Where's the 2020?
2019.
I have a lot of 21s.
This is 2022.
Yeah.
There's 2021 for you. Okay, that one.
Okay.
I'll take one.
Don't have any that say
This is
2020?
22.
Don't have any that say 2020. You said one is 20.
2021.
So what are the
Said
3
there were
dates? What are the 3
3.
dates?
2019, 2021, and 2022 are the years.
Okay.
Yeah, I
So
got
need
21
I
and
have all
19.
21s here.
Here's 22.
22.
Yeah.
Here's 22 is coming in.
What do you have there?
Okay, right.
This one has a pyramid in it.
First one, the 19 does, but.
The 2022. October 12th, 2022. I think those are extra.
I didn't get it 22.
I handed it to you now.
This is a 2022.
Okay, yeah, the big one. No, okay, so Denise. Is that for her?
This is 2022. Yes. All right. Okay.
Richard Whalen, attorney for the owner of the property, Irving Fain, from Whalen Filer PLLC. First of all, I want to make it clear that I think the board understands here. The purpose of the appeal is that the neighbor who lives on Hopkins Avenue, Mr. Ferrandino, returned from Florida, I believe, back in April, came to his property at Montauk and saw that there was construction going on the seaward side of his property. He'd had an ocean view, and as soon as Mr. Fain began to build the second story, that ocean view was basically blocked. Andy has explained to you that the nature of the geography in this area. I think that Mr. Ferrandino believes that the loss of his ocean view is due to either the owner or the builder violating the town zoning restrictions in terms of either height or pyramid law. It's not true. I'm going to demonstrate to you that the building conforms with respect to height and pyramid law, and any claims by the neighbor that there's a zoning violation regarding either of those are simply not true. He lost his view to simple geography. If any of you have been into the area, been to the property, just look around. You're going to realize the Ferrandino lot is about the same elevation as the Fain lot, which is the subject property. And if you build a two-story house on the Fain lot, which Mr. Fain has chosen to do, Ferrandino is going to lose his ocean view. And that's what's happened. And he's not happy about it. And I can understand that, but there's no violations concerning height or pyramid law on the Fain property. So there's three basic points I want to make here. Number one, I understand that the current owner, I didn't represent him on the real estate transaction, but Irving Fain, he's the true owner through an LLC. He bought the property, as I understand it, last year in 2021. I was engaged at the end of April in 2021. He had an architectural firm. The building permit, remember, had already been issued to the builder, who was Mike Brosnan. He engaged an architectural firm, I guess, to look at and maybe change or tweak the building plans. That firm was Damon Lease Design. And from May through October 2021, I had numerous interactions with representatives from Damon Lease Design, emails and phone calls. Many conversations with them and many email exchanges. They wanted to know, they were not familiar with town zoning. They wanted to make sure that whatever they were doing, whatever they changed in the building plans, they were conforming to town zoning. So they asked questions about height, pyramid law, fencing, the window well in the back of the property, setbacks, swimming pool, pretty much everything except the wetlands, because at the time, I didn't realize there was a wetland across the street because it wasn't shown on the survey. I will point out I did not visit the property during that time. All of my work was based on the surveys and building plans that they supplied to me. But I do believe that during that process, they understood what the rules were. They had, as I said, numerous questions. I gave them, I think, correct answers. And, towards the end of the process, my last interaction with them was in early October of 2021. They had a set of building plans. I don't know whether they ever actually changed the plans before the building department, but they asked me to look at those, and I confirmed based on the information shown in the plans, they appeared to conform particularly to height and pyramid law. So the people involved on the architectural side of this thing were doing their due diligence. I think my client, Irving Fain, through his architects, was also doing his due diligence. So I just wanted to make sure you understood this was not just
some fly-by-night operation, at least as concerns the current owner. Constructive notice, Andy just referred to it briefly. I know a little of the facts, or I understand some of the facts as explained to me by Mr. Ferrandino concerning when he learned of this. I think he came back up from Florida in April. And again, he saw construction going on and he began to inquire about it. And that's when he got notice. The question, which is a legal issue, and you probably don't have to really worry about it, but the legal question is, when did he get constructive notice? The house began to be constructed, or the addition began to be constructed in the fall of 2021. The only reason that Ferrandino didn't know about it is he wasn't in town for a period of about 6 months. So, I mean, we're going to argue that he has constructive knowledge of something going on, you know, in plain view if he were there. And therefore, he should have known he had a duty of inquiry earlier in the process to find out what was proposed. Second, once he knew that there was an issue, at least in his mind, we think he should have brought sort of either a TRO or a preliminary injunction in the courts to stop the continuing construction that goes on to this very day by Mr. Fain, because otherwise Mr. Fain would be at risk working on a project that his neighbor believes is not legal. So again, I don't think the issue of notice is going to be important because I think it's all moot. And this is where I want to turn to the surveys. So I've given you 3 surveys. They're all by David Saska Surveying.
Can you just for us be clear if constructive notice is being brought up, what are the key dates in your mind?
So the appeal was filed on June 7th, 2022. The requirement under the law, so the requirement of the code is that you are required to file an appeal within 60 days of the filing of the administrative official's order, determination, permit, whatever. The original building permit was issued in 2020, but no construction occurred for a long period of time. And it's understood by the New York courts that a landowner who doesn't actually know about the permit, like a neighbor, can't be charged with knowledge of when the permit was issued in 2020 because they would get no notice of it. So we understand that. The question then becomes, when should they have known? And the normal rule is when construction begins. When construction of the neighbor's house that you're going to complain about begins, okay, well, now you know something's going on. You don't know the permit was issued. The permit might have been issued a year earlier, but now you can see something going on. Ferrandino's excuse was, I wasn't there. And okay, if you're not there for the weekend.
What's the earliest date that you think he has constructive notice?
The fall of 2021, when construction work began on the property. There would have been a building permit posted and construction began. I don't know exactly when construction work began, but I know it was in the fall of 2021.
That's when activity started on the property.
That's when my understanding activity began on the site. Again, remember, my last communications with the owner and his architects were in early October 2021. So at that point, they had gotten all the information from me. They had finished their plans, whatever they were going forward with.
I got that.
But at that point, there's.
All right. So first of all, height. The first question is height. Couple basic points here. We have a survey from Saskis from 2019 that shows in exhaustive detail the pre-existing natural topography in the property. We all know, that height is measured from any point on a structure directly down like a plumb line from that point to natural grade. You have to know natural grade. The appellant is making a lot of talk about how the grade has been substantially changed, and that's an ancillary issue. And I understand, not an inconsiderable issue here, but in terms of where the natural grade was, which is what you measure height from, we know it. Cascas did a survey of one of the exhibits I gave to you, 2019. Just to give you an example, besides having 2-foot contours, 2-foot elevation contours over the entire property, he also has spot elevations. There are on the back property line 9 separate spot elevations, either on or almost on the rear property line, and another 3 spot elevations in that rear yard between the pre-existing house and the rear property line. So we know the elevation, plus there are other spot elevations coming forward in the property. So between the spot elevations and the contour lines, we have a very, very good idea of what the initial natural grade was on the property. We also know the finished product because the house is under construction. It's fully framed. I was there today. I was in the house. I was in the back of the yard. I was in front of it. There's construction going on at this time inside. They haven't fully finished the walls, but the house is completely framed. And if you, so we know where the roof is because the roof has now been done. So the roof has been surveyed by Saskis at 80.0 feet elevation. A flat roof house, as you know, maximum height of 25 feet. So this is a simple measurement. If the roof is at 80.0 feet, in order for the house not to exceed maximum height, it cannot be built at a grade that's lower than 55 feet elevation. So I'm going to turn to the 2021 and the 2022 surveys. The 2022 survey is only about a week old. It's dated 10/12. It's an as-built as far as construction has gone so far. And I just want to take you down two sides of the addition. So there was a pre-existing one-story house on the property. I'm just going to mention in passing, that house, that part of the building was reconstructed. I think, Chair Deline had a question about that. It does appear that the entire original, house was rebuilt and then the addition was built onto it. The pyramid nonconformity, that house, even though it was one story, was so far close to the rear property line that it actually had a pyramid nonconformance. And if you compare the 2019 pyramid law drawings to what there is today, the pyramid law nonconformance for the original one-story house as rebuilt is lower. It's more conforming to pyramid today than it was before construction began. As far as the addition goes, and I'll come to that at the end, the addition is completely conforming to pyramid. So let's talk about height. On what I would refer you to is two surveys, the 2021 survey, which is 10/1/2021, and then I'll call it the as-built. It's the more or less up-to-date survey, which is 10/12/2022. I'm looking at two different points along this. The area of concern for height would really be the southeastern point of the building and the southwestern point of the building. In other words, the points closest to Surfside Drive. So along the northeast side of the addition, if you will, the northeast side, so I'll call it the northeast corner of the building. I guess that would be northeast. That's the corner that is now shown on the latest survey as 174.1 feet from the wetlands. That corner, remember, the roof is at 80 feet. That corner sits directly above, almost directly above the 55-foot spot elevation for contours. So it's directly above 55 feet. It's 80 feet high. That's 25 feet. That corner complies. Everything between there and the rear property line is at the natural grade is even higher. So your height will be lower than 25 feet. The southeastern corner, this is in the area where there's a proposed deck shown on the 2022 survey. And it's the area that's labeled, if you look at on October 1, 2021, it's an area with a number 4 there. I guess it was originally proposed to be a second-story deck. It's now actually part of the house. You see the number 4. So I just want to make sure we're on the same place here. It's the southernmost point of the building addition. That, closest to the bottom of the page. That lies between the 54-foot and the 56-foot contour. You can see that on both of those surveys, both the 2021 and the 2022. And I just want to make sure you understand that in 2021, it was shown as proposed. I have compared it by measuring with the 2022 survey, and that southernmost corner is in the same place. There's a little bit of a jog or a notch to the right of it because they extended the front of the addition, a little bit closer to Surfside Drive by about 5 or 6 feet. But I'm looking at the very southernmost corner. That's in the same place today as built as it was proposed in 2021. That's between the 54 and the 56-foot contour. Remember, if we're on the 55-foot contour, there's no height violation. It appears to be a little closer to the 54-foot contour, suggesting that it might be a little bit below 55 feet elevation. So Saskis and the 2020 and the brand new survey, the October 12, 2022 survey, has at the bottom of the page 4 different drawings showing height and pyramid law compliance. He concludes that southern corner of the building is 0.2 feet above the allowed height. That's 2 to 3 inches. So there does appear to be a very slight discrepancy at that south corner. 2 to 3 inches is within the discretion of the building inspector, we call it the 6-inch rule. There is a provision in the zoning code 255 I think it's 10-40C, which says the building inspector shall have authority to issue a C of O when a dimensional variance of not more than 6 inches is required due to inadvertent improper siting of a building or similar circumstance, and the building inspector in his or her sole discretion believes such relief to be warranted. Note that, and you can see it on Saskis' drawing, that only compromises a very small portion of the building where apparently the natural grade was a little bit below 55 feet. So there's a slight discrepancy there. It's certainly not what the neighbor was thinking about. And it's within Ann Glennon's discretion to vary that. If she were not to, I guess the owner would have to reduce the height of the roof in that corner by 2 to 3 inches. That would be it. I do want to make one other point regarding to the roof height. This is all based upon the understanding, which is building department policy, that glass railings do not count towards height. They count towards the pyramid law. That's the building department's position. They count towards the pyramid law. And by the way, this is advice I gave to Damon Liss, the architects, but they don't count towards the overall height. So I think when Jameson earlier was referring to an 82.4 foot height to the railing, you need to know whether that railing is a glass see-through railing or, some other opaque structure. If it's a glass railing, which is my understanding of what the client proposed on the roof, then you only look to the roof height. That's 80 feet. There are also pyramid law drawings that are on the most recent survey. If you can look at the pyramid law drawings, they're at the bottom of the page. They're taken from 3 different angles. They're taken from the rear, which is I guess it's the west. I think it's the west elevation, where presumably Mr. Ferrandino would look. And they're taken from both the north and the south sides. The addition itself does not have any pyramid law violations. The pre-existing 1-story house did transgress the pyramid law before all this began, and it transgresses it less today than it did before the project began. The bottom line, the conclusion is the house as built complies with height, with inspection of a very minor discrepancy at the southern corner, and it complies with the pyramid law. There's other issues I understand about the grade and so forth. I just want to comment quickly on that. My understanding was that the builder told Ann Glennon that he intends to eventually remove all that fill. He didn't want to have to remove it and then bring some of it back to the site. So it's temporarily stored there. We certainly understand and agree that if there's a permanent change of grade within 150 feet of wetlands, that requires a natural resources special permit. But my understanding is that it was represented to Ann, this was temporary storage. And, if it's not fully removed and there's a change of grade, then the owner would have to go and, apply for an NRSP to legalize what the final grade is.
Thank you.
Okay.
Is the glass railing part of the prints that have been submitted to the building department?
I've never actually seen the building plans, but I know from my discussions with the architects that glass railing was proposed. They are proposing a roof deck, and they're proposing to have a glass railing to enclose it.
Wouldn't it be on?
Well, it doesn't have to. It'd be part of the C of O. If it didn't, they would verify that, I think, at the C of O.
All right. Thank you.
Thank you. Right.
Good evening, board members. Well, I guess I'm coming forward. Good evening, board members. Brian Frank, Chief Environmental Analyst with the Planning Department. You can swear me in, but I really don't have a
Brian,
lot
do
to
you
offer.
swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I'm not really here representing the building department. I'm happy to answer any questions that you may have about the application. I do. Ann Glennon was unavailable this evening to attend in person. I do have some of the information from her files. Some of the survey that was submitted with the building permit, which Jameson showed you in her presentation, the under construction survey that Jameson showed you also in her presentation, some site photographs from her initial investigation about the concerns about whether the grade had been altered on the property. I discussed that with Jameson earlier today because I hate to be sandbagged at a hearing. I wouldn't want to do it to anybody else. I'm not representing the building department. I want to be clear about that. I'm here to help the board in any way the board desires that helps you make a
One question
decision
that
on
would
the
be,
application.
what could be directed your way is about the temporary fill within jurisdiction of wetlands. Is that a problem in your mind?
In my opinion, it is not. I did discuss it with Ann when it was brought to her attention. The wetland is across the street. It's my opinion that as long as the fill is adequately contained so that it can't run off, so that no sedimentation of the wetland can occur, I would not advocate for people on a regular basis applying for natural resources special permit for the temporary placement of fill. I think that would really bog down the board, the planning department with a lot of temporary applications. There's a potential serious environmental condition if fill is not properly contained relative to wetlands. And obviously, the closer the wetland and the steeper the slope, the greater the risk. In this case, the wetland is across the street. You can see a portion of it here. It's bisected by this driveway. This is the closest portion of the wetland. You saw from Jameson's photos, it's contained in fill. I suppose by letter of the law, even temporary placement of fill arguably needs a natural resources special permit, but it's not something I would advocate for.
Thank you. Any questions for Brian?
No.
I have, if you'd like me to make sure that Ann Glennon's photographs or her department's photographs get into your file from the date of that visit, I'm happy to do that. I think a lot of the other information that she had given to me, you already have from Jameson.
Yeah.
Thank you.
Ann is available to call in, and she just doesn't have a phone number. Can you just minimize that? Because I think it comes across the.
$888-6331.
The number's also on YouTube, or it's also on ltveh.org.
Should we call it?
And here she is. Let me let her in.
Thank you, Matt.
And unmuting last four digits, 8849.
Hello, is this Ann?
Yes, hi, this is Ann Glennon, building
Okay,
inspector of the town of East Hampton. Hi.
And do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. Can you give us some background on this particular case?
Sure. I mean, I don't know where you're at this point. Sorry, I just came from another meeting. Yes, this was a particular where they came and they applied for a building permit to add an addition. They met all the pyramid, everything. Work got a little extended more because there was more damage, but they left the remaining. There was a question that they changed the grade. We went out numerous times, starting back in, I think, February. I submitted pictures, May twice, and took pictures where the grade by the house never really changed. We could see the bottom of the fence. We can, everything that we looked at the grade. Then we required them also to get us an as-built survey. We had the survey from original and then the as-built. And still, there was no reason for us to have anything to say as far as that the grade had changed for them to make the house higher. In fact, it looked like the house dropped more than raised.
Okay, and in your mind, one of the applicants, contestants, that there was a nonconformity that was increased. Do you want to address that?
Sorry, where was the non-conformity? I apologize.
Well, I
Not
think it
really.
was,
I wasn't aware of that.
it was pre-existing non-conforming to side yard, to rear yard setbacks, I
the-
think. And
The rear
and-
yard, that part of the building, and that didn't change, that stayed.
Okay.
And they're allowed to keep that, they just can't make it more non-conforming, which they didn't. The addition went towards the front where they met pyramid and height.
Okay.
What about the suggestion that it's a complete redevelopment and not an addition and an improvement? What's your view on
They
that?
came in for addition. It happens all the time once they start taking apart a house like that and they start getting into it and adding new foundations and everything, then they come in and they get additional permits to finish doing what they're doing. I mean, it's like all these houses, they come in pretty much for an internal gut job, and the next thing we know, by the time they're done redoing the shingles and the roof, because it's all considered maintenance, it becomes basically rebuilding the house. It's been going on all over town right now. And then we make them come in to make sure that nothing else has changed and get additional permits to cover it.
Is that what happened here? Did they get additional permits along the way?
Yes, they did. Mm-hmm.
Thank you.
Anybody has any questions? Terry?
No, I just want to make sure we have all of Ben's documents.
Yeah, well, Brian, if we can make sure that he's not here, if we can get the documents uploaded onto the site, that'd be good. All right, anybody have any questions for Ann?
To give a read.
Brian, one of the concerns, if we can just make sure that Ann's documents are uploaded in the public files.
Yes, Mr. Chairman, I'll make sure.
I think that's it. Jameson, you want to come up and do some closing? Keep it brief.
Yeah, very brief. I'm actually going to ask if it's okay with the board because there were two surveys, one from Mr. Hammer and then the most recent 2022 brand new from this week survey. I haven't been able to really look at these. If you could leave the hearing opened, I don't know if that is something you'd be willing to do so that I could get a chance to review it and just respond, or I can try to respond very quickly right now.
No, we can leave it open.
Okay.
How much time do you need?
Not much, whatever you're comfortable with. When can we come back?
No.
Or do you want me to just do it by paper?
You need a week, 2 weeks?
2
You
weeks.
Tell me.
2 weeks, yes.
Okay.
The two things I wanted to say, because there was a question, the glass railings are not part of the plans. That was news to me that the plan is for glass railings. That's one thing that is demonstrated on the building plans that were relied on in issuance of the permit. It's on sheet A07. So it does describe a 2x4 rail and 4x4 posts with it has it on here. It doesn't say glass. It's drawn. It's, the cable. So I wanted to mention that. Also, in terms of the constructive notice, obviously, I will have to go back to my client and nail down the dates. We discussed that when I submitted, but if you look at the building card, there may have been work in 2020, there was a stop work order in November because they were working outside of the permits. But then by the time that they said in fall 2021, if they were working, their permits were expired, because you see on the building card, one thing you do see is March 7th, 2022, they renewed those permits. So again, my client said that he had constructive notice. We do have photos. There's nothing from February. Ann and I did exchange some photos, so I can go back and confirm those too. They're saying it's not an issue, but I wanted to just make that point that if there was this alleged work being done in the fall of 2021, I don't think that the permits were active. And it does seem like they renewed them in March, and then this really started getting moving at that time. So that. And then in terms of the temporary fill, I just asked that the board and we can explore this further, that, obviously the word temporary is being thrown around. If it was in 2021, which I don't think is when this work really started, when was the fill really deposited and what really is temporary. I mean, we filed in June. We did not pursue a TRO because in fact, we were told that there were valid permits. So we were questioning the issuance of the permits and the validity of the permits, not that there were no permits. But the fill has been there since at least April and now it's October.
But our temporary fill, isn't that verified by a final survey?
Excuse me?
Isn't all that verified by a final survey?
The recent survey and their survey show the fill as being there. So yeah, it's actually there as if it's existing. And then that survey demonstrates that the 5 feet of fill was deposited there in the front yard.
Right, but we don't have a final survey yet.
And they don't
Right.
and they don't have a permit for that fill.
Right.
So
Okay.
my point is, what does temporary mean? Maybe we can, get to that point.
Okay,
Thanks.
thank you. Can we have Andy, guys, this has gone way too long. Can you keep it quick?
1 minute. Good afternoon, Richard A. Hammer. I just want to point out that Ann said they visited the site in February based on complaints of the neighbor to check the grade. That's constructive notice. They were calling Ann. At that point, they should have filed an appeal. Second thing I just want to point out is that we did submit HERS ratings. This is using an AI sanitary system. So the reconstruction standard under the code or the substantial improvement was in fact intended to be, done, and everything was in compliance with it. The only other thing, and I hate to do this, but if she's going to reply to the record, I would want to have an opportunity to respond to it, which I think is fair. We haven't had notice about tonight until recently. If you give me like 4 days after she submits, and perhaps
We'll keep the record open for 3 weeks.
okay
2 weeks, 2 weeks for
her
you and 1 week.
Okay, that would be satisfactory. Thank you.
Okay, thank you. Can we have a motion to close?
I'll make a motion.
Just for the record, we have 0 additional callers. Thank you.
Thank you. Thank you.
This is just to keep the record open.
Then in the case of Peter Ferrandino, 73 Surfside Avenue, Montauk, Suffolk County Tax Map 300-051-02-10, I make a motion to close the public hearing, but to leave the record open for an additional 3 weeks.
I'll second it.
Concur.
I concur as well. Our next hearing is Kathy O'Sullivan at 130 South Forest Street, Montauk, Suffolk, tax map number 300-28-7-34.1. The size and location is 40,463.62 square feet, located at 130 South Forest Street, Country Club Estates, Section 2, map number 5152 in Montauk, Suffolk, tax map number 300-28-7-34.1. The description is to construct 2 additions to the residence totaling 442 square feet, 354 square feet of decking and 80 square foot of roof overhang, a 72 square foot staircase, a 200 square foot pool house, 1,000 square foot pool deck, and a 480 square foot swimming pool, full fence, and a parcel of land containing freshwater wetlands. The relief sought is a natural resources special permit pursuant to 255-420 and 6 variances from 255-430 wetland setbacks are required. Variances of 74.7 feet, 67.9 feet, 55.7 feet, 58.3 feet, 18 feet, and 5.5 feet are required. To construct a roof overhang, 25.3 feet, a staircase, 32.1 feet, in addition, a foot to the residence, 44.3 feet, decking, 41.7 feet, pool fence, 82 feet, and a swimming pool, 94.5 feet respectively from a wetland where 100 foot is required and any other relief necessary from the town code. Zoning district is B, Zone X, flood zone, and the secret class is type 2. And council, do we have a proper affidavit of service and posting?
Yes, pursuant to the town of East Hampton code, we do have a proper affidavit of service in this case. It was filed within the 10 days, specifically on October 5th, 2022, to all parties that were adjoining properties.
Thank you. And who's,
Okay, it's mine.
okay, Terry?
This is a parking area. It's a very large parking area going across the front, and this property has a buffer in the front. But anyway, next shot, I believe, is the official notice posting was properly posted. Took a little web reading, but still legible. This side turn, and this is the house directly across the street from the applicant's home. Next, we're going to look, this is southward on South Forest. You can see this was a rainy day, and this is an area that is prone to a lot of runoff into the streets in the general neighborhood. Next. And this is the shot in the other direction up north. It's right on the corner. Well, it's not on a corner, but it's the last house on South Forest. After that, there's a house that's actually called Ferris Street, and not many houses on that street. Next, and this is a shot now of the front of the house, and we're gonna go up next. Now, I went across to the northern side of the property. This is roughly, well, sort of in the area where I believe the IA system is going to be. It's actually probably a little farther north outside of the picture, but we do have other photos coming up. And the pool, as you can see on the survey, is situated generally in that direction also. See some more of that later also. Next. Now I'm standing in the driveway and shooting across to the north, again in the general vicinity of where the pool is proposed to go and the pool house. Next. Now I'm standing on the southern side of the house facing east. And you can see in the distance there's a pond and the wetlands. Well, there were wetlands actually to the side, to the south also, and to the east that are on this property. Next. It's just another shot showing some bluestone walkway. I believe it was slate or bluestone. Next. Now this is a shot toward the back of the house, and this is a shot of the area where they're proposing the stairs and the addition. I believe that's what they're going to do, is enclose that. Ask them to enclose that. Next. Now I'm standing, I walked toward the back of the property, and there are a couple of steps that were put there, and this is some of the wetlands and the pond that's immediately behind the house. Next. That's another shot just generally of the vegetation in the area, and again you can see the pond on the side, and this is in a southerly facing direction. Next. And that's now facing kind of northerly, more northerly. It just turned in the other direction from that same basic location, again, to show the vegetation. Next. Now, this is, well, from that area, this is showing the back of the existing home where there is a proposed deck, rather, on the back there. It looked like it will go from the sliders across the front of the window. And next, now this is the north side of the house, and this is where there is the other addition that is proposed along the length of the house there. Next. Now from that same area where I was standing, I just took another shot. There's a neighbor, well, that's a home that's actually on another street, because again, the pond is in between that, and just another shot of the area, the lawn and the vegetation toward the wetlands. Next. And now this is the front of the house where there is a proposed overhang that I believe, is, well, proposed overhang that I believe is just going to cover the entranceway there. And next, now I turned, and again, I'm shooting toward the northwest side of the property. A lot of vegetation there, but it's part of that is in the area, again, where the septic system is proposed to go. And next. That's just kind of another shot of the same, but you could see the street out at the distance. So this is actually being proposed, the septic and the pool in the front, more of the front area of the home. Next. Oh, and this is off the driveway. This is where the existing septic is. It's just off the driveway that is there. It's the existing one today. And is that it? That's just another shot out of the street. Again, that parking area. I'm not sure if there's an issue with that or not. I believe that's it.
Yes.
Okay.
Thank you.
Joel?
Good evening, Joel Halsey, on behalf of the property owners, half of which are here tonight. Karen O'Sullivan, the O'Sullivan family, representing Lighthouse Land Planning as well. Would you like to swear me in?
Yep. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do. Okay. As per my April 25th memo, I just wanted to revisit the history of this application. I'm sure you've read it a few times as it is in the file. The project was originally designed to be a conforming pool, decking, and a pool house. During the design, I convinced the property owner that a sanitary upgrade in conjunction with this project would be beneficial to the overall application. This was discussed with the planning department, and the idea of upgrading the sanitary system in place was a possibility at the time and would have been exempt from natural resource special permit requirements. However, doing this would leave ample room to design structures relating to the pool in a conforming location. At that point, I encouraged the property owner to design the sanitary as far from the wetlands as possible. Doing this would require pushing the pool closer to the wetlands and within variance jurisdiction. The discussions I had with the planning department regarding this at the time were encouraging. The project was in the process of redesign. Then COVID became a huge pandemic, as we all know. The property owner has since moved to the property full-time and thought a small addition to the residence would provide all the room that her family of 4 would need. This addition does not provide any additional bedrooms. It just allows for more dining space, closet space, additional bathrooms, and storage. So the overall intensity of use on the parcel will not be increased by an increase in bedroom count. The project is modest in all aspects, and in conjunction with the sanitary upgrade, it is an overall great project. The technical analysis memo states that the soils within this area are muck, and then it goes on to list the characteristics of muck soils. It does appear that the planning department got this from the Suffolk County Soil Survey, which is a great tool, but not entirely accurate when it comes to mapping, as one can see by reviewing this document. What is more accurate would be to review the test hole data on the survey. The soils are in fact a mix of loam, clay, and sand. The muck soils found within this area would most likely be at the bottom of the depression where you saw the standing water within those pictures. And that's speculation on my part as well. The fact that the muck soil type is, to speculate that the fact that the muck soil type is found throughout the property suggests that the wetlands in this area were more extensive prior to the construction of South 4th Street, and any development in this area does not give consideration to the multiple different soils throughout this area as depicted within the soil survey and the test hole, which does not describe the soil as muck. I'm not arguing that there's not muck soils in these areas. I believe that there are, but just to characterize this whole property as muck just makes the project sound much worse than it really is. The clearing as described within the technical analysis memo does not require a variance and is within the property's allowable clearing. To that point, we are amenable to a revegetation of the property within the area of the house and the wetland. An extensive revegetation plan was submitted on August 8th, 2022. This plan proposes to revegetate the property so that there's less clearing than which exists now. It should be known that and most likely witnessed by the board member, by Member Berger, who visited the property today or recently, that a majority of the clearing required is not native plants, but non-native invasive or ornamental plants. And I did submit pictures attesting to that on April 25th. The vegetation consists primarily of honeysuckle, greenbrier, and privet. Any native vegetation has been choked out or is in the process of being choked out by vines. In fact, one could argue that the clearing required for this project does not constitute clearing under the residential district clearing provisions of section 255-2-60, which allows for the removal and maintenance of dangerous deadwood and non-native invasive species. The clearing of this non-native vegetation with a revegetation full of native plants, in addition to the lawn areas that will be revegetated, on the wetland side of the residence will greatly increase the environmental benefits of this property. Please note, if no pool was proposed in order to install the sanitary system within the most conforming location of clearing, the amount of clearing would be proposed would be relatively the same if we weren't proposing the pool, because the sanitary system, being as far from the wetlands as possible, would be in that same, we would try to get it in that same location. The amount of clearing would be relatively the same. The TAM does suggest, the technical analysis memo suggests that the applicant addresses the increase in non-conforming gross floor area. The application is proposing small additions totaling 442 square feet. The town planning department typically considers the threshold of substantial to be 50%. I am unaware if this has changed since I worked for the town. To that point, a 21% increase in gross floor area is far from substantial. And to segue from there, the decking that's proposed is also just a modest decking. And as you can see from the one picture that was taken from the water facing the house, you can see it's lawn right up to the house. This is just going to add a small area, I think about 328 square feet of decking that the applicants can use, especially since that area is, most of that area will be proposed to be revegetated at the end of the project. Regarding the location of the pool, there is no other possible location so that the pool can be located 20 feet from the sanitary system as required by Suffolk County. We have reduced the decking within the area of the south side of the pool to eliminate the variance that was required for that decking. The pool, however, cannot be slid in any direction further from the wetlands. As earlier stated, the pool only requires a 5.5-foot variance. This is far from a substantial variance request. Whether or not a variance is granted by the Zoning Board of Appeals is a balancing act, based on the 5 standards that's detailed in section 255-8-50 of the town code. In deciding whether to grant an area variance, the board shall consider the following factors: whether the grant of the variance will cause an undesirable change in the character of the neighborhood, or will it create a detriment to nearby properties. This will not change the character of this neighborhood, which is developed with single-family residences of all sizes and designs, some of which have pools. The small addition will not significantly increase the mass of the house. The pool decking and the pool house are all amenities that can be viewed throughout this neighborhood. If the board desires, there's a 36-foot space between the road and the proposed pool. This 36 feet is all located within the subject property, and this is more than ample room to plant screening for the pool and the pool house, so it could help buffer the pool and pool house from the road.
I'm sorry, is that shown on the revegetation plan, or that's something additional?
Excuse me?
Is that shown on the?
No, it's not shown. I'm just I'm just giving an example that,
Got it.
there is ample room between the pool and the road to screen the pool from the road if the board desired. Whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than an area variance. The location of the existing house makes this impossible. There's no conforming location on this house. With regards to the pool, we have shifted the pool closer to the wetland to increase the distance from the wetland to the sanitary system. We believe this is a good trade-off, and in discussion with the town at the time, they seem to agree. Whether the requested area variances are substantial, one could argue that the variances for the house and the decking attached to the house are substantial. However, this is the minimum variance necessary to achieve a small addition with some additional decking. The variance request from the pool is not substantial in any way. In fact, only a small arc of the pool, if you see on the survey, is within the 100-foot wetland setback. I'd say probably only about 30 square feet, maybe 45 square feet of the pool is actually within 100 feet of the wetlands. Whether the grant of the area variance will have an adverse effect or impact on the physical or environmental conditions of the neighborhood, or the affected area of the town. We believe with the proposed vegetative buffer between the house and the wetlands, a slight increase of overall vegetation, the removal of invasive species, and the sanitary upgrade more than offset the impact of the proposed project. And whether the difficulty causing the applicant to request the area variance was self-created, which consideration shall not be relevant to the determination of the board, but shall not necessarily which consideration shall be relevant to the determination of the board, but not necessarily preclude the grant of any variances. I've always found this a little bit odd, because it seems like almost every variance that's before the board is a self-created variance, unless it was a builder's error or something to that effect. Every variance seems to be self-created. This is a self-created hardship. The house was bought by the O'Sullivans after the adoption of the Natural Resource Special Permit and wetland regulations, but as stated within the standard, this shall not preclude the grant of any variance. If the board has any questions, I'd be happy to answer them.
No questions, but the variances are very large for the overhang.
Only for the addition to the house.
And the additions and the overhang also.
The overhang, which is essentially just so you put your key in the door.
Concerns about the natural resources special permit. This is, the property does slope slightly down toward the wetlands. There's a lot of grass, and yes, you're offering a revegetation plan, but I guess
we're offering a substantial buffer between the house and the wetland than it would exist today. It's pretty much a lawn right up to the wetland. We're only leaving a small open area between the house and the buffer, in order to have just a small lawn space there. We don't want to revegetate up to right up to the deck, which is definitely a possibility if you want to see more revegetation on the property. But again, that's, a substantial revegetation for a 442 square foot addition to a house with 354 square feet of decking. Again, it's the minimum variance necessary. The house is pre-existing non-conforming. There's nothing we can do about that, short of picking the house up and moving it back 100 feet, or not quite 100 feet, but 40 feet, 50 feet. But again, that's not really in the cards here. What is in the cards is a small addition to allow for additional bathrooms in this house and a larger dining area.
And that's also increasing the nonconformity then too.
It's increasing the nonconformity by 21%, which is definitely not something the board has not.
Isn't the total addition to 442 in our project, and the notice, it says 226?
That was corrected by me a while ago. And in fact, the board canceled the public hearing back in July because the property was misnoticed.
Okay.
But it has always been 442 square feet. I do not know where the 226 came from, but
that was corrected. So
that was corrected before the schedule of the first public hearing. There's memos in the file. But again, this is a 442 square foot addition to not a large house. It's a relatively small house.
It's 5 bedrooms, isn't it?
It's a 5-bedroom house, but it's not 5 large bedrooms. Again, you could fit 5 bedrooms in a 1,500 square foot house if you wanted to. The house itself is let's see. I'd have to pull out the plans, but again, yes, it is a 5-bedroom house. They do have 4 members of their family. It allows for 1 more bedroom for a guest bedroom, and 5-bedroom houses are not uncommon.
And have they considered, I know the variance for the pool itself is not, but again, it's an NRSP also. Have they considered all to just make the pool smaller and bring it outside?
I believe the pool is relatively small to begin with at 480 square feet. It's not a large pool. We are requesting solely a 5.5-foot variance for the pool. And again, it's for maybe 45 square feet of this pool. It's not a large portion of the pool. And again, we did this in discussion with the planning department. We tried to do the right thing. We moved the sanitary system as far from possible from the wetlands. This was my idea. I brought it to the property owner, moving where they could have upgraded the sanitary system pretty much close to the wetland, leaving a conforming envelope for the pool. Shame on me maybe for doing that to having the property owner do that, but I don't think so. So I believe, for the sake of a 45 square feet of the pool being within 90 feet away from the wetlands, I think that's an adequate trade-off for.
What's that around the pool? Is that hardscape? It looks like it's an elevated pool.
The pool is elevated. It will meet the groundwater. To meet groundwater around the pool, there is decking. I mean, there's decking around the pool, but I don't believe anything's proposed on the wetland side of the pool, except for a little bit. With anything within 100 feet there's nothing proposed within 100 feet. No hardscape. We could put vegetation in there. It probably would be a wise idea to put vegetation to screen the height of the pool, because again, the pool will be out of grade. So that there is nothing proposed within that area right now. There is a small, a set of stairs on that side to get up onto the deck outside where the pool house is, but I believe that's the only hardscape right now proposed. And I don't believe any new hardscape will be proposed. And obviously, if it did, it would require a natural resource special permit.
And in the TAM, it also requests that an explanation as to the The 4 dry wells that are there, the rationale for that?
The 4 dry wells to
Proposed off the driveway?
No, total 7, but yeah.
Well,
I believe that might be addressed in the protocol that was submitted. Again, I don't remember reading that in the TAM, so I must have missed that in the TAM. I would have to look into I believe that they are 4 dry wells for the pool, whether they, they have to be that, maybe the location for them would be consistent with where, a dry wells for the pool, and they might only be 2-foot deep dry wells. I'm not quite sure what the calculation would be for drainage of that pool, but I'd have to double check into that if you'd like.
Yeah, Joel, you mentioned that a couple of times about removal of invasives. Is that to be in the area that's be principally disturbed by this work, or is there? So there's no intention to do removal of invasives any further than the part that's on the landscape plan that we have in those areas that are most affected, right?
We will not exceed the proposed clearing boundary.
So this area that I was over to the site as well, and the area that's currently lawn that goes down to a small buffer between the pond and the lawn area is to be increased based on this landscape plan, which is part of what your client is offering up as as some sort of remediation for the work that we're being asked to do, that and the septic system. Correct. All the work that's on the landscape plan, though, that's around the pool is really necessitated by the fact that we're doing you would be putting in a proposed pool. So that's why we'd have to do this additional planting. Is that right? Because right now, when you're there, anything, as we've seen in Member Berger's photos, anything to the north of this cleared area, which is just slightly north of the perimeter of the house, is already vegetated. So you're going to be opening that up to put the pool in, and then revegetating and taking out invasives.
And we're also, taking out, for the sanitary,
Yeah, for the sanitary, and then you're going to, of course, that'll be regrassed.
That'll be regrassed, and that obviously we can't put woody shrubs over the sanitary system, and that will not count towards the revegetation numbers because it is over a sanitary system, and I believe that does not.
So the old sanitary system comes out at the front of the house as it is right now. That sanitary system comes out. We're not looking for any regrading in that area. We're going to follow natural grade, put in 4 dry wells.
Correct.
Those 4 dry wells to pick up water that you say has been engineered as it was necessary for the site.
Yes.
And then just to return to this thing about the landscape plan, what we're looking at here then is essentially the area between the rear of the house and the pool is being offered up as new planting area as a buffer between, buffer between the house and the pool with the, I'm going to assume, 4-foot wide access path down to the pond.
Not pool, but you're talking the pond. Yes.
Pond,
Exactly.
Yeah. Okay.
And I did speak to Brian Frank about the revegetation plan, and I'm sure he's going to address it in a minute, and we are amenable to upgrading that plan any way the planning department sees fit.
Okay. Ready for the planning department?
Yep, thank you. Brian?
Do you mind if I stay here during this?
That's fine.
Brian Frank from the planning department again. I'd like to show you the property on the aerial, and if you bear with me a minute, I think I have to stop sharing and reshare a different screen. And I can't see what you can see on your screen there, so if you can tell me when
See 2
it's up.
ponds.
We see 2 water.
Yeah.
So you can see the
Yes,
hand?
we see that.
Okay,
Yeah.
all right. So this is the property. I'm sorry, I got knocked out and had to log back in, so I wanted to do it right. But what I wanted to show you here is this is a pretty unique area in town, and especially in Montauk. This is the subject property. The wetland or the pond that you see on that aerial is part of a chain of ponds that runs through the Country Club Estates, largely a reserved area. This area was really probably all swampland before the subdivision was built, before the roads were built. And that's when the soils were mapped. The soil survey mapped these areas before the roads and the properties were developed. Joel and David Rhodes from TF Engineering are partially right about the limited accuracy of the soil survey at a large scale, calling everything muck here. but there's a limit to the accuracy of that. You also can't only go by the results of the test hole data to understand the soils on the entire property. The test hole data comes from near the street. There's definitely fill that was been brought to this area. These ponds were excavated out. They were probably dug out of swampland. I've been in here in a number of them many times over the years. They're connected by culverts and concrete head walls. The higher elevations are in the western part where the applicant's property are, and they descend in elevation. They kind of cascade one into the other as you go to the east. Regardless of how much of the actual property would qualify as muck soils under the soil survey, this is an area that contains extensive freshwater wetlands. This is an area that contains poor drainage throughout most of these streets. It's not uncommon to see street flooding. It's not uncommon to see the storm drains in the street backing up. It's not uncommon to see water flowing down gradient through these streets. Throughout many of these cul-de-sac dead-end roads that comprise what sometimes we refer to as the South F streets of south of the golf course, whether it's Fisk, Fuller, Forest, you get the idea. It's an area of widespread wetlands and widespread poor drainage, regardless of whether they're all muck soils or not. And the extent of poor soils here is somewhat of a concern. There's perched water as close as only 7 feet down from the surface. And again, I think it's reasonable speculation to suggest that a fair amount of the property was filled prior to contemporary wetland regulations. And that's probably the upper layers of the soils that you see there are not so much native soils. Another point that's worth pointing out in Montauk is Montauk soils are notoriously ununiform, even in areas that lack fill. This is an area of extensive glaciation. It's not uncommon for soils to differ from each other over a short distance. There are glacial erratics, there are clay lenses, and there are areas where there's fairly deep to clean sand. But it is a mosaic. It is kind of hit and miss. And I'm not saying that to suggest that the applicant should dig more test holes to show that what the soils are here. But it's a fair representation of the area to call it poorly drained. I'd like to go back to the survey if you'll give me a second. I think I have to do the same thing. I have to stop sharing and then reshare to get back to the screen. And hopefully that's up.
We got it.
Okay. So another thing that you can tell from the aerial photo that was up is there are a large number of properties that share similar environmental conditions to the applicant's property that we have on the lot here. This application was reviewed by my colleague, Eleni, at the time, and I believe that the substantiality of the variance that she was talking about was not necessarily the square footage, but the numerical setback. We have a 100-foot wetland setback in town. The location of the wetlands in the southern portion and the eastern portion of the property obviously preclude that. But the additions are proposed pretty close. The southeasternmost addition, it's within the gross footprint of the house, but it's pretty much as close to the wetland as you can get without bumping that footprint out farther. The most conforming locations on the property are to the north and to the west of the property. And the board really has to evaluate if this is the type of application that you want to see repeated throughout this area of Montauk. I think, again, you see the number of dry wells that are proposed here are probably also indicative of the extent of drainage. This pond and this chain of wetlands is a Class 1 wetland. Again, it's very unique. This chain of ponds is very unusual. There are areas that are pristine in terms of their vegetation, some good vegetative diversity in some areas. Permanent standing water. This is not a seasonal pond. It is a permanent pond. we've addressed the square footage. With regard to the revegetation plan, especially because of the invasive species here, I haven't seen very many revegetation plans outside of duneland areas, which use a lot of herbaceous material, where herbaceous vegetation has any real staying power. The landscaping, the revegetation that you have right now is comprised mostly of rushes, grasses, and wildflowers. There's going to be a vestigial seed bank of invasive species here. Those invasives are going to choke out soft stem herbaceous vegetation the same way they're choking out the more substantial woody vegetation that you have there. If this application is approved, the buffer here should really consist of woody native plants, and that's something that the planning department consistently recommends on most revegetations because of their survivorship and their hardiness. They don't get mowed down very easily. They don't get replaced very easily. They have a little bit more staying power against invasives than something like butterfly weed, which is a very important native plant. So is flag iris. But you know, another factor, and I certainly don't want to accuse anybody of anything, but revegetations that look like a garden tend to get treated like a garden, and plants tend to get replaced, and people add colors. And the idea of a revegetation is to naturalize an area, not necessarily beautify an area. So if this application is approved or any variant of it is approved, this area between the house and the pond should really be indigenous shrubs. The revegetation over the sanitary system has to be herbaceous. You can't have substantial root systems over the leaching system, especially on these newer sanitary systems. But most of the revegetation should be hardy native woody plants that are, again, that are a little bit more rugged and a little bit able to have staying power over time. The board's going to have to evaluate whether there are better alternatives to this application, whether an addition should be done in another manner that maximizes wetland setbacks, that increases those setbacks. And Joel and I had an opportunity to speak before the hearing. It appears that these contour lines, excuse me, that these black lines on the survey are not contour lines, but utility lines here. And if the swimming pool is approved, that's important because it's the planning department's opinion that adding a substantial volume of fill and changing the grades in proximity to wetlands in an area of poor drainage would have adverse impacts on those wetlands. So again, I don't see any elevations on here. I think in the sanitary plans, it's a little bit more clear that those are utility lines. But significant regrading in here would be problematic in the opinion of the department. Beyond that, I don't know if the board members have any questions that I can answer. I'm certainly willing to try.
Questions? Harry? No. Well, I would just want to revisit something I've already talked about here, and that is the re-veg plan. And as you pointed out, that you would like to see an upgrade on the re-veg plan, particularly in the areas that are going to be most sensitive to helping protect the pond. That area that's behind the house that currently is primarily mowed lawn, goes back to be revegetated. It seems like that's a substantial step forward in providing a buffer. Now, would we be asking the applicant to come back to you for some additional advice about what kind of vegetation we're looking for if we were to move forward with this? Is that something that would make you feel in any way better about what's been proposed between the house and the pond?
What would make me feel better if it was built into any determination that the board issue that the revegetation plan can consist predominantly, if not exclusive, of woody native species to Montauk. I don't really have the time to go back and forth and haggle over revegetation plans. It's become far too common, and frankly, I don't have the patience for it anymore. This is our recommendations. This is your decision. You can allow them to do whatever you want. You can require whatever you want. Our recommendation is that revegetations be indigenous, commercially available, predominantly woody. Maybe not exclusively, but that's what we're going to recommend throughout Montauk, especially. And that needs to be incorporated in your decision. Otherwise, it becomes just too much haggling back and forth, and we don't have the staff or the time to put into that. The plan that you have is very artful. It is all native. Those are plants with high wildlife value. I don't want to diminish or denigrate the amount of thought that went into it. But in terms of environmental mitigation, it's just not practical.
Thank you.
Thank you.
Well, if it were approved, if the application is approved,
Right.
you would still have to approve the re-veg plan.
Well, the plan ultimately would get approved by you. We would advise you on that, but ultimately, it's your decision. It's your mitigation.
Yes.
Good. Joel, I do have a comment and brought up with Brian too, and looking at it. You look at that pole structure, it's a substantial structure, but I don't see any is there drawings on that?
Yeah, there on the survey, there is are you looking for?
You're looking at a survey, but there's no elevations, there's no cross sections. You see,
and then there's
but that's just showing a pool shell. That doesn't really give you what's happening here relative. Let me see. All right, I'll take a look at it.
Yeah, and the pool house and the pool deck are all going to be right at the same elevation with the pool, so you can pretty much just walk out of the pool house and onto the deck and into the pool. Okay. So with regards to the revegetation, I will definitely work with, it was Jim Grimes Landscape, Fort Pond Native Plants. I will work with him to develop a plan that would be amenable to the board, the planning department and the board. I understand Brian's reservations. He does not want to haggle back and forth over, what should be there and what shouldn't be there. I understand what he wants. I will work through it with Jim Grimes, and we will come up with something that the board will definitely be happy with.
How much time do you think you need?
Excuse me?
You want more time then?
No, I believe, again, if you can incorporate it into the determination, that, again, we wouldn't be able to build anything.
That's kind of conflicting with what Brian.
With what Brian was just saying.
It's kind of how you guys have always
making it. Brian, your objection is the haggling, not the submission of you're going to have to review it no matter what.
No, I think it's better if you're going to grant it, put language in there as to what you're looking for in the re-veg, and then let them submit a plan that matches the condition of your determination.
Okay.
I think that's more practical than having somebody try to design a plan in anticipation of an approval which is not a sure thing.
Yeah. And I don't want to rehash too much on the muck soils, beat that one down like a dead horse here. But again, we would be more than happy to throw a couple more test holes on the property if you want to see something. The test hole on the survey, I think, does go down to 54 feet, not showing muck anywhere. So even if there was fill brought in at one time, the soils show, no muck all the way down to, clean sand as the county requires. With regards to where the location of the addition. Now, it is, although maybe it's not the minimum variance necessary, there is basically no other location.
We addressed this already, didn't we?
Yeah, well,
I don't want to rehash.
Brian did bring it up, saying that there's a more conforming location for the addition to the house. And again, he's right. There is a more conforming location for the house addition. However, the addition was designed to work with the house, not to pick up, 5 more feet for a wetland setback. So to say that, yeah, we could have met a better setback if we designed an addition on the northwest side of the house. Yes, we could have definitely met a better wetland setback. However, that wouldn't work with the existing design of the house. So you're looking at having to do a gut renovation of the existing house just to do a 300 or 400 square foot addition to the northwest corner of the house. We designed the location of I didn't design it, but the design of the addition was designed to increase, allow for a few extra bathrooms, 2 extra bathrooms, closet space, and additional dining on the one side. Well, it would be hard to design that meeting the greatest possible setback to the wetlands.
Okay. Thank you.
So we're closing the-
Matt, is there anybody in the public that would like to speak?
You have
Matt,
0 callers. Thank you.
Okay. So,
Everybody-
so we are
Closing it.
close.
Right?
Yep.
Yes, okay. For the application of Kathy O'Sullivan at 130 South Forest Street in Montauk, tax map 300-028-07-34.1. Make a motion to close the public hearing and the public record.
I'll second that.
Concur.
I concur as well. Thank you.
Okay.
Thank you. We're going to table the decision on Nicholas Family Trust and move on to building permits and certificate of occupancy. On deck is Bruce Bistrian, applicant, 45 Private Road, Amagansett, Suffolk, tax map number 300-110-2-12.16. And that's to determine compliance with the determination made on September 19th, 2019. And board members, I'm recused for that. So Vice Chair, I'm to you.
Thank you very much, Mr. Chair. Brian, you're going to walk us through this?
Yeah, we didn't get anything, right?
I will. I'm going to get kicked out of the computer. The computer's going to restart in 2 minutes, and I don't think there's anything I can do to stop it. I feel like this is like a movie all of a sudden. There's no way I can make it go later. No, it won't let me remind it later. So it's going to shut down in a couple of minutes. I'm going to summarize it. I'm sorry, I'm not going to use the computer as a visual aid. The Bruce Bistrian property is off of, I think it technically has a Napeague Harbor Road address. That's the road on the east side of Napeague Harbor. It obtains its physical access from a dirt road that parallels the southern portion of the property, the harbor, and extends farther south. The board had issued an approval in 2016 for a single-family residence. The work has been completed. They've applied for the inspection as a prerequisite of a CO, and there are some differences between the approved survey and the as-built survey as summarized in a memo that I prepared for you a little over a week ago. There are differences in the coverage, total coverage and clearing. There does appear to be the difference in coverage may be explained by a covered porch that was not included in the proposed survey that was then picked up as building coverage in the as-built survey. That doesn't explain the differences in the total coverage or the change in clearing or the fact that the driveway extends a little bit further south, including into the delineated wetland. I know that Britain has opinions about why that is that way, and I think it's most appropriate for her to provide that explanation to you rather than to me to recount the discussion that I had with her. Based on, I think there are two questions for the board. Does it satisfy the conditions of your approval? And if it doesn't in some way, does it require a formal modification? I've been speaking with counsel about the modifications in general, and in our opinion, in the planning department's opinion, what should count as what I would call a traditional modification, which was more administrative on the part of the board, done at work sessions rather than a rehearing. You're going to get your legal advice from your attorney and not your environmental analyst. So I think, stop me if I misspeak, but the type of differences that I just summarized, even under any circumstances, sound like the kind of circumstances where it requires a rehearing. I'm not a fan of having everything go through the rehearing process, but I don't know what else to I don't know what else to say. I don't know how else to advise you, and I don't feel comfortable making a recommendation, even if I supported the changes in this project, giving you advice that I don't believe your council is going to endorse as well.
Yeah. So the question to us then becomes whether or not we want to require that a modification be filed, an application for modification be filed by, I guess it's Bruce Bistrian on this.
Well, I don't know if it would be more productive to table this discussion. I guess it's not really, I think you probably at least want to hear, even if you get it in writing, as to from the applicant's perspective, how they believe this decision comports with the determination. I don't mind telling you that I had, concerns about this application when I reviewed it in 2016. That's kind of beside the point now. It was granted. It is what it is. But I think at least you should probably entertain something, if nothing else, in writing, to be fair to the applicant. But before you make a decision as to whether it complies with your decision or not, and if not, then make the next steps. I don't know how that sounds to you, Hope.
Well, to me, go ahead.
You got it.
Oh, I was just going to say, to me, it seems to me that we need additional information from written on this, the applicant, because we're not in the position right now to review exactly what they determined happened to put us in this situation. I mean, how did it happen and why did it happen? We know it exists. Someone's raising your hand.
Is she allowed to speak? This is a work session?
It's going to be up to the board if you're. I just want to make.
Written.
Sorry.
Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do, particularly on this application. I just want to make two factual. I know that I'm not allowed to speak or present, but I want to make two factual things. There was an incorrect statement in the lot coverage increased. The lot coverage actually decreased. And in terms of the narrative that I was asked to submit and the surveys and documentation, you've had that in your file since last week. So if you would like me to read what I wrote to you, I've already done that homework and it's already contained within your file. It was submitted both digitally and in paper, and I can stand here and read it. It's a very short, 2-paragraph that explains it. My concern is that I really don't want to go down a rabbit hole here and spend, this department is completely backlogged, and I'm sure you hear this all the time, but these is one of those things that could turn into, the holidays and months and months and months. And it's holding up flood insurance. It's holding up occupying a new house because it didn't have a CO before. So there's some things that are pressing on this that I'd rather be able to move forward. I personally think that the changes that were made, let me just read you what I submitted to your file and you can verify that it's there. Dear Chairman Deline, he's recused, but as per discussions with Board Attorney DeLauder and Planner Brian Frank, I'd request the ZBA review my pending request for a certificate of occupancy at the above address. It came to my attention that there's a Scrivener's error in the 2016 survey, which the board reviewed for NRSP and variances. That Scrivener's error was, and Walbridge submitted a letter to your file confirming that this was the case. When they did propose lot coverage, which is roofed area, they actually didn't even include the total square footage that this board approved for the first floor.
Right.
It was proposed 1890. The first floor of the house was 1900. And there was a covered porch of 400 and a covered entry. I can't remember, but what ended up actually being built was less than what this board approved by about 5 square feet. So the lot coverage did not go up. In my conversations with your counsel, she said that is something that is a Scrivener's error, and it doesn't need to be deliberated any further because I've proved with the letter from Walbridge and the 2 surveys that was in fact just an error. The second, can you pull up the survey?
I gotta get back in. I'm working on it.
Okay.
I'm working on it.
It would be helpful to be able to visualize it, but I'll try and explain it. if anybody doesn't know where this property is, and I welcome you all to go there because it speaks volumes if you look at the access. As you all know, I'm a fireman and EMT, and this is actually in my district, and in my backyard, and it's my parents' house. So I'm pretty well versed in emergency access there. The Napeague Harbor Road is the paved road that runs north to south. Private road is a road that runs generally east to west off of Napeague Harbor Road. Where they intersect, it's a private road owned by the trustees, the town, and halfway down by owners on both sides. It's very complicated. But what that serves to say is it was never entered into the road system. There's no drainage. There's no concrete. It's a dirt sitting in marshland road. It's very hard to access. And until I started construction on this house, it was actually a dead end. It goes down about 2,000 feet in dead ends. So if you ever were trying to get down there, you couldn't actually get back out again. As part of this construction, we restored what used to be a turnaround at the end of the road for the fact that I didn't want it on my watch, contractors working and not getting an ambulance down there or getting someone out. But literally, we took our own money and cut in this turnaround. So when I started building the house, beyond that access issue, then the road from the dirt road is 300 feet to the front door of the house. In New York State Fire Code, it says that if you have a driveway of a certain length, you need to provide an emergency access turnaround because you can't drive straight down a road and not be able to turn around. So in the construction, the building on the clearing envelope was so small. I will note that it was about 5,000 square feet that this board approved for clearing, but we were approved for over the allowable clearing on the lot, which was 10,103 square feet of temporary construction clearing. So that's what I had sort of said to council is my clearing went up a little bit, but the board approved clearing 10,000. And the fact is I'm down at 5,200 or something like that. And it was literally to sort of mitigate this long rutted narrow road posing a significant hazard and not being able to, in good conscience, to design this house and not be able to turn around with, the two owners being in their mid 80s in the dark where there's no streetlights in Napeague at night off a 2,000 foot long dirt road. It's about as remote as you get in this town. And I know that firsthand. So I felt that this non-substantive change to the project scope, we did more revegetation than we needed to do. We're revegetated up to, Hope and I had discussed it. Was there anything else you can do? We literally revegetated up to the structures. You can't even walk around the perimeter of the house because it's all reveg. I mean, it's a house that's plopped down, and please take a ride out there because you'll see what I'm talking about and try and turn around. The turnaround as it exists is almost insufficient, and it's hard. It's a 5-point turnaround, but it's a turnaround. It's better than nothing. And so, to go to public hearing, I don't know what the public's going to say about that. And I also, a driveway, unlike in another structure, doesn't require a variance. A driveway just requires an NRSP, and this property has an NRSP, and it had an NRSP for 5,000 more square feet of clearing than we ever undertook.
Temporary clearing, you said?
The temporary clearing. And it's a couple hundred square feet over the approved, but literally the square footage that is approved is the same square footage of the turnaround. Like there's no other divergence to anything.
Okay, well, Brian, I believe, made a statement that it actually goes into driveway ended up being more south and actually into the wetland.
Can we pull it up?
Yeah, I got it.
Just kidding.
Sometimes it's hard to struggle without a visual.
I mean, I know the area you're talking about.
Yes, so the entire driveway, unlike most, is wetlands on both sides, and it's 12 feet wide and 5 feet down on either side. And so there's really no area on this parcel that wasn't wetlands. To achieve this turnaround, there's no other mechanism. So the area that we're talking about, so just to orient you, this is coming down private road. This is the 300-foot long driveway, comes down, and you meander. This pinch point right here is about 10 feet wide, maybe. It's about a foot wider than a car where it comes around the deck. And you get stuck here. You can't, there's nowhere else you can go. So I had to put a little tiny bit of a turnaround to be able to make a 6-point turn to get out of there. So this is the area that diverges from the plan.
And what's the dotted line? Is that
That's the edge of the marsh,
the end of the,
or the edge of the crags.
So the total square area affected by this turnaround that bridges into the marshland, into the wetlands? We know how much that is? I mean, it's just a corner, you don't know the area. I'm just saying it's part of that little 10-foot wide turnaround.
This is the area that changed. So
Yeah.
this corner was a circle.
Right.
So that's the area of change, and that's, that's the area of the.
Right.
4 square feet. Plus or minus 6 square feet, maybe. It's under 10.
But it's something like that. It's something in the range of 10 square feet or less.
Yeah, and I don't know of any other way with the structure to get out of hire the architect. This is why I left my career as an architect, because this was the last house I designed. And it's a problem. And it's not a problem that I want to have.
Okay.
And I don't know how a public hearing.
I see what you're saying.
so what's our decision? Is it that hearing versus an official mod, or this was? Because I'm looking at online and where it says CO Britain, there's nothing there. There's no files, no records.
I don't know what you're looking at.
Online on the website.
On
There's
our
a folder
website.
there, but I don't, do you see documents?
Shocking.
I read her
my name.
memo.
What?
Can I,
My files are always empty.
Okay, just a second, Brian, make a comment, please.
I'll let Britton finish, but I have some thoughts about this that I'd like to share with the board.
Okay, I'm sorry.
Thank you.
If there's not more information in the file, that's my fault. I scrambled to get this done before I was going to be away. This is a 2016 condition. I would encourage you to review your determination and what was proposed and what was offered at the time. I wouldn't expect Britton to agree with the way I would characterize this application, but if you recall, and you'll take a look in the file, this application, the justification for it was basically because the Bistrian family gave so much land in this area to the state of New York for parkland that they basically, my words, not theirs, got a blank check from the DEC for doing what they wanted on the lot they wanted the lots that they have left. My concern is that you're going to see more projects like this. You've already seen more projects where when you have got something so constrained and the setbacks are so tight, we're seeing a lot of as-built deviances, and there really has to be some accountability on the part of the applicant to adhere to the limitations that they propose. The fact that Britton's a firefighter in this district notwithstanding, she was the agent for this application. And if there was a turnaround consideration, that should have been incorporated into the original design. And if that affected the house, so be it. The clearing of 10,000 square feet was temporary and everything else needs to be revegetated. There is a change in total coverage here that is not accounted for in a Scrivener error or any other error. I don't know where it came from, but that's how tight this property was. And I think the board has to keep that in mind when you look at this. One thing I agree 100% with Britton on, you should go there and take a look at it. You should go there and take a look at it, and you'll see if you go back to your original survey, you'll see how close to the elevation of the marsh the whole project is. And the driveway still isn't stable. It's still runneling off sand into the wetlands on either side. And I don't blame anything that the applicant did as a result of that. That's not a result of poor construction, sloppy design, irresponsible mitigation practices. It's just a product of what happens when you bring fill into a wetland that's almost at sea level. But you really should review your decision. You should review your history. I kind of hate the conundrum that we're in on modifications. I had thoughts that I've shared with both your current council and your prior council on doing things more the way they were done prior to 2020. But coming back to this specific project, I do have some concerns about the as-built conditions, and I've expressed them to you in the memorandum. Britton's had a copy of that memorandum. I don't relish having a hearing on this, but I don't know how this complies with you. If this complies with your decision and other things require modifications, I have a difficult time explaining that to other members of the public and understanding it myself. But maybe you should start with taking a look at the decision and to see if there's any to see if there's anything else that can be done with the property to remediate the conditions, to bring it closer to your conditions of approval, so that a more formal action isn't required. And that's kind of, I think, anything else that I could offer now until you've had a chance. I know Member McGivern was on the board when the application was reviewed, and I believe Member Berger was. So I recognize the fact that Council, Member Johan and Member Savarese were not board members when this application was heard and approved.
Okay, so this is the as-built. that Brittany gave us. Okay, and you sent us a memo? I apologize, I don't recall seeing that, but maybe I just missed it.
I've read the memo, so it exists.
Yeah, no, I'm sure it exists somehow. I missed it.
It had the determination, it had the approved
had all
survey,
that.
it had
Okay.
the paper copy didn't, but the email attachment had everything that I thought the board needed as background to kind of discuss this in form within whatever the term is.
So I would like to look at all that again.
What are our procedural options, counsel, here?
I do believe that the calculations are, after looking at them, are administrative in nature, and that could be done by amendment. I do not believe, though, however, that the cutout is administrative in nature or can be done as an amendment. I do think, for the fact that they were both sitting up here arguing, that there is a record to be made, clearly, and obviously to be made, even if nobody else comes in from the public. To be made at a public hearing, just to preserve the record and to have both sides and additional submissions and whatever else needs to be submitted, officially submitted into this application. That being said, I do understand there's a lot of issues with the whole modification versus amendment. But I do believe that this is a unfortunately a change to the original conditions of the application, is my understanding, and I was not here for that, so you'll have to make that judgment call on your own. But it does seem like it appears like it was a little bit more of a change, and that there would be some type of additional consideration for it, even if it was minimal, and even if the record just needs to be made for that point. So, and if you're going to go out to the site again, where does that information go if you don't make a record? So if you go out to the site and you guys discuss it among yourselves, and it's not put onto a formal record, right, how do I define that legally if need be?
Okay, so at this point, do you want to have something?
I just, because there is a record and I find defamation kind of an issue, I just want to point out that I just need to say, because there are people that watch this, that my family gave 50 acres to the New York State DEC for preservation for no exchange of money. So this blank check thing that I just heard, I just want to make sure that's not true. We gave 50 acres. We have a letter in 1983 from the DEC that said, thank you for your gift. In exchange for that, we will recognize your half-acre lot as a building lot. It took my parents 40 years to build on it, but that's the actual facts, and those are in your record. And I also find it very difficult to stand up here because Brian did recommend this for denial, and it's not helping to not have somebody who has an open mind on this modification. So if there's a way to make that change and maybe Tyler can represent it, that would be welcome as well. But whatever the board wants, you're welcome to come out to the site, meet me. I just ask that you take it expeditiously. I submitted everything to the file that you should have. Brian's memo was submitted. It does have some inaccuracies in it, factual, but if you need anything else, let me know. The lot coverage did not go up, Brian. It didn't.
Excuse me, Britton, I took the coverages off of the survey.
Thank you very much.
Okay.
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 We don't have.
Clarify something.
Okay.
The information in my memorandum came from the survey that was submitted by Britton. Britton could have taken a look at that survey and noted that the coverages and clearing didn't match what was approved and addressed it before the inspection request was made. The inaccuracies that she's purporting, I took right from her paperwork. I'm sorry she considers my characterization. I didn't know that she would agree. It was certainly not meant as defamation, but the DEC, in my own conversations with them, had given a lot of the DEC in 2016 whenever they issued the permit gave a lot of consideration to the Bistrian land donation in reviewing that application, because it was it's as a standalone application in a real sensitive area. It is a little unusual that there was if that was interpreted as anything untoward on the part of anybody. That was not the intention. Let me clarify that. And but that is part of the history, their land donation, and that's why honestly, at some point, you've got to review the record for yourself instead of me putting words into it. You know, I did my best to get this to the board as quickly as I can and represent it as fairly as I could. I didn't know that Britton was even here, and I didn't want to give you my opinion about the as-built conditions without her presence here, or an opportunity to let her explain that in the interest of fairness. So the idea that I am going to be unfair in reviewing anything subsequent, I also take a little umbrage of. It's pretty clear how I felt about the initial application. The board grants approvals on stuff that I've recommended denial all the time. It's not personal. It is what it is. It's a matter of working through what it is now. We're certainly not going to unbuild what's there. There may be some remediation, but anyway, I felt like I did have to get that on the record.
Okay, thank you, Brian. So for us, we're faced now with how do we want to handle this? And we're going to recommend a hearing. I want to hear from the other board members here about what they feel about where we're at. It seems like we have some information here that's not only in conflict with one another, but maybe has to get aired as was recommended by council. But
Okay, but I don't know that I'm ready to make a decision about the hearing until I see the records. So can we put this on next week's agenda?
Sure, we can, for an administrator.
Procedurally, is that something that we can do here? Is just table this till next week till we all have a chance to thoroughly review the record under the circumstances? How do you feel?
Yeah. Is this technically an Amagansett?
Amagansett, yeah.
Maybe this is.
Okay, so if we go in that direction, that we're going to table this till next week, what is our next move, council? We make a motion here, or do we just take?
Just go ahead and make the motion to table it to next week, and then we can talk off the record about.
Okay.
Can go back
You
out.
okay with that? You're okay with that?
Yeah.
Okay, then in the case of Bruce Bistrian of 5045 Private Road, Amagansett, Suffolk County Tax Map 300-110-02-12.16, I make a motion that we table this discussion until next week, until the board can become totally familiar with the information surrounding this case. That sound right to you, council?
I concur.
We all concur.
Did we
Thank
need a
you.
motion for that? No.
Thank you.
Welcome back to chair.
All right, with that, we have minutes approval for September 27th and October 11th.
Okay, well, I'm going to make the motion for the 27th because she did change the one thing that I wanted to table last week. So for the East Hampton Town Zoning Board of Appeals minutes of September 27th, 2022, and make a motion to approve.
Concur.
So backwards.
Second. Okay, I'll concur.
I concur.
Okay, I left a message for her because there were a couple of things on the 11th minutes.
We can
and-
table that,
Yeah,
too.
so let's table this one. I don't know if she did them or not because it was kind of later in the day.
Okay, in resolutions, we have Jason and Jillian Hurst at 56 Jacqueline Drive. Amagansett, Suffolk Tax Map number 300-176-5-1.
I'm not sure if you guys want to make the decision on this tonight. We can hold off if you didn't. I know I sent the decision around very late, and Denise did not comment on it, and she normally comments on everything. So
I was going to make a comment on that.
Okay,
There was one thing.
So then we can table it,
So,
it's still
yeah.
fine and would be within its time limits if we table it to next week and then we get the decision out.
Okay, we're timely enough. Okay.
Then we have, yep. Then we have Dan and Julie Resnick at
Wait,
72 Shore Road, Narragansett, Suffolk Tax Map Number 300-107-01-22.
So this one did have, I didn't have any comments on it, but it was sent around last week, so I'm assuming everybody read it. This was for the amendment, not a modification. We're going to rephrase it as an amendment. This particular property was essentially just asking to amend the building plans. The windows and the doors and the location of the chimney had changed in the survey. It did not affect any of the variances that were granted to this board. It did not affect any of the wetlands, beach vegetation, or anything like that. This was approved and obviously by all board members and written as such.
Okay. Make a motion?
Joe, yeah, because it's up against it, I'll do it, whatever you want.
Who has it on? It's not on my.
Yeah. In the matter of Dan and Julie Resnick, 72 Shore Drive, Amagansett, Suffolk County Tax Map 300-107-01-22, I move to approve the resolution
That's written.
as written. Excuse me.
I'll second.
I'll concur.
I concur as well. All right, thank you. And Vice Chair, will you close us out?
Good. Then I'd like to make a motion to close the East Hampton Town Zoning Board of Appeals hearing and work session for October 18th, 2022 at 9:10 p.m.
Second.
Concur.
I concur as well.